Is it Amy that's going to do?
Only we can't get to the page drive. And the map drives link is on here.
Morning, Martin.
Good morning, sunshine.
I'm trying to reach that side. I'm working on it. I'm looking this morning. I was so grateful I didn't have to go that far. You got the memo to read.
Into that map drops link is up there, you put that and then you have the drop show right there, but that map drop is not.
Okay.
Already back and forth. I like to there's a way. This was sometimes it's out there, sometimes they hide it.
I think that's what we need done. It's the little icon behind it.
Time for us to connect with the tribes, to reach like the partners and then a K drive is not accessible. And working our computers, our other computers are that have, running a page that says on that webs or whatever, just simply click that. Again.
I know. Yeah.
Networks, yeah, but it must be OCDC networks. Yeah. They were at you.
Do you want me, we can pull one of these chairs out here and give you, so you're not sitting in there. Okay.
Well, we just. I think he's on the problem talking.
Yes. This one's working from the top.
These one person.
Don't say Veritex court reporter.
You can say that.
That's all it's on.
Okay, good, all right. I just didn't want you to do this because you can, I can do it. So I want to be right.
Oh, okay. No, we're good.
Thank you.
Good for emailing your chair.
So.
How are you?
Or actually,
Be careful of those two little things out there.
yeah. And I don't know why they don't have that installed. That's like.
Okay.
No.
You're all right, thank you.
We try to get on here. The right. Nice and dry. So we just.
Is it the same one?
Yeah.
Do it, let us install the mat rise, solve our.
Yeah. Oh, yeah.
I don't have a. Yeah, well.
No way out.
I always.
No, see that miles away.
Awesome. Am I the man or what?
Yeah.
You know, the gift for you and for me.
Now you're getting.
You have a laugh when you open up. Yeah. Unfortunately, our problem is.
Bring it in.
And everything that directly contributes.
Oh, yes. Jesus, right.
Yeah. Good. Oh, sorry, go back. Sorry.
Yes.
Sorry.
You're listening.
Easy.
No, by the way, we're not watching. No, I mean, I don't so it's my, that's my mind right there.
And so what's last night, I popped it off, big thing. And we walk back and then push it out. I thought I was like,
No, they're.
Oh, okay.
The CLT operations, those are really. So the only one that's. Yeah, that was. Right.
So, I'm like, what's that, that's.
I assume.
Yeah.
It's my clients.
Thank you, appreciate that.
So I guess it could switch it back into.
This, was run together. Well, you can't, you've got to figure out what the break is, because the setback, and then it. And I'm reading it.
I guess I throw him behind. Yes, there's a lot of history.
(2025). My name is Deborah Dryden. I'm the chair of the board. Would the board members please go around and state their names for the records? Mr. Williamson, we'll start with you.
Marshall Williamson. Kevin Shea.
Amy Winnie Stein.
Wesley Davis.
Thank you. Also present are Solomon Fortune, our zoning administrator, John Kinley, senior project manager, Crystal Monsegur, the planner, Kamisha Lampley, clerk to the board, Therese Hagler Gray, senior assistant city attorney, advisor to the planning staff, and Jill Sanchez Myers, senior assistant attorney, advisor to the board. Welcome back, Jill. And Wanda Clark, our Veritex court reporter. Each of today's hearings is a quasi-judicial evidentiary hearing. That means it is like a court hearing. State law sets specific procedures and rules concerning how this board must make its decision. These rules are different from other types of land use decisions like rezoning cases. The board's discretion is limited. The board must base its decision upon competent, relevant, and substantial evidence in the record. A quasi-judicial decision is not a popularity contest. It is a decision constrained by the standards in the ordinance and based on the facts presented. If you will be speaking as a witness, please focus on the facts and ordinance standards, not personal preference or opinion. General witness testimony is limited to facts. For certain topics, this board needs to hear opinion testimony from expert witnesses. These topics include projections about impacts on property values and projections about impacts of increased traffic. Individuals providing expert opinion must be qualified as experts and provide the factual evidence upon which they base their expert opinion. While hearsay evidence is not specifically excluded, it is only given limited weight. Parties with standing have rights to participate fully. Parties may present evidence, call witnesses, and make legal arguments. Parties are limited to the applicant, the city, and individuals who can show they will suffer specific damages. Other individuals may provide testimony as witnesses when recognized by the board. Witnesses must swear or affirm their testimony. Any individual wishing to speak as a witness today was required to sign up. If you haven't done so, please do so now. The parties to each case are entitled to an impartial decision maker. A board member may not participate in a hearing if they have a fixed opinion about the matter, a financial interest in the outcome of the matter, or a close familial, business, or associational relationship with an affected person. The parties to each case also have a right for any ex parte communication to be disclosed. Ex parte communication is any communication about the case outside of the hearing. That may include site visits as well as conversations with parties or the general public. At the start of each case, any potential conflict of interest or ex parte communication should be disclosed by a board member, if applicable. These matters may also be raised by any affected party. Today's meeting will follow the order printed on the agenda. Today, we're not starting with the recommended, we're starting with the variances. All parties who plan to give testimony must be sworn in. A city staff member will present a summary of the case. The board may question the staff member, and then the applicant may question the staff member. The applicant presents their testimony for the case, and any sworn witnesses provide testimony. The board and city staff may question the applicant and their witnesses. Other parties wishing to speak for or against a case will be given reasonable time to present sworn testimony. The staff and then the applicant will be given opportunity for rebuttal. After hearing each case, the board will review each case and render a decision. This is usually done in closed deliberation after hearing each case. The chairperson calls for a motion and a second to approve or deny the variance or appeal. The decision will be made by a simple majority vote of the board. However, the board may elect to take up to 30 days to render a decision. You may remain present during the deliberations, or you may call the zoning staff after the session to receive the decision of the board. If you wish to receive a written copy of the decision letter, please indicate so on the sign-in sheet. All exhibits must remain with the board. If your case is not appealed to Superior Court after 30 days, you may pick them up or they will be destroyed. Appeal from this board is to the Mecklenburg County Superior Court. You have 30 days from the date of the board's written decision in which to appeal in accordance with NCGS 160D-405D. All right, let me swear in, please, all of the Mr. Solomon and Crystal and thank you. Okay. All right. Do you solemnly swear or affirm that the evidence you shall give to the board in this action shall be the truth, the whole truth, and nothing but the truth, so help you God? Thank you very much. All right, Mr. Kinley, you may begin. Oh, you want me, because we're doing variance 2025-00002. Okay.
This is a variance request by John Carmichael, actually, it's John Carmichael representing Chick-fil-A for property located at 14111 Rivergate Parkway. Variance request is from section 11.4052 of the legacy zoning ordinance, to reduce the required 35-foot setback from 35 feet to 27 feet, which is an 8-foot reduction. Here's a map of the location of the property. It's down at the Rivergate Shopping Center, down off of South Tryon Highway 49, heading towards the county boundary. Here's a aerial view of the property in Rivergate Shopping Center. I think the Best Buy is the building there at the corner closest to that. Here's a close-up aerial of the property. It's zoned CC, Commercial Center Zoning District, and that is a legacy zoning district that is also a conditional zoning district. So there is a conditional site plan for this area, but you all are seeing it because the section that they're needing requesting a variance for is a base standard of the ordinance and not something that was specified on that conditional zoning plan. Again, here's another view of the aerial. And let me move, sorry, I'm just gonna move this out of the way a little bit. All right. Here's street view of the property. This is looking up Rivergate Parkway towards 49 is over here. There's Rivergate. And this is the Chick-fil-A's drive-through that's coming around the building. So the variance request again is from section 11.405 2 of the legacy ordinance, reducing the front setback from 35 feet to 27 feet, which is an 8-foot reduction. This is the proposed site plan that they have showing the requested reduced setback. It's kind of hard to see on here, but where the dashed kind of striped line is the boundary of the existing drive-through lane. And that's also where the 35-foot setback line falls. So basically that striped line is the 35-foot setback. What they're wanting to reduce it to 27 feet is basically the extent or limits of this new drive-through lane that they are proposing. And again, that's to create double row of circulation around the building, around to the pickup window and exit point. This is just a cross-section view of that same site plan. So here's your building, drive-through lanes come around the back side of the building, 2 lanes of drive-through traffic. Here's where that existing 35-foot setback line falls. They reduce it to 27 feet. It would allow them to have a second drive-through lane, which is the reason for the request. This is the approved, administratively amended approved conditional plan. It was approved in 2006 for the Chick-fil-A, and it shows the 35-foot building parking setback. And again, over here on the more detailed plan, it's where that line shows here. And just for context of what's going on in the area across the street is also another parcel, Zone CC, it's a McDonald's. They had their plan administratively amended, and basically what administrative amendments mean is it's a administratively approved change to an approved conditional rezoning plan. And there's certain changes that staff is allowed to make to those. For most of the stuff in Rivergate, a lot of it was staff's approval of building elevations, and then more detailed plans of actual out parcels, because the overall rezoning just had a general layout of the out parcels. So when they come in for their development approval, they get a more detailed plan that goes through permitting. And those, again, recognizing the 35-foot setback along Rivergate Parkway. Here are the standards that apply to a variance. These are from basically the same as what you'd see in the UDO. The hardship standards are the same. So hardship resulting from strict application of the ordinance, conditions that are peculiar to the property, not resulting from actions taken by the applicant, and consistent with the spirit and purpose and intent of the ordinance regulations, such that public safety is secured and substantial justice is achieved. And I'll give you a second to look over the findings of fact before I move on.
John, can you go back to the streetscape picture, the one with all the green? It was one of your first slides, that one. So will still be some green if we approve this between the drive-through and the sidewalk, right? It's not coming right up to the sidewalk.
Basically it would be a drive-through lane that would extend roughly to this point. So there would be, I don't know how exactly they'll grade that, or if they'll put in a retaining wall, because it does drop down a little bit. But the wall here and the flowers and these trees would remain, and that's shown on their cross-section plan here.
Okay, thank you. All right, you may continue.
All right, so looking at the findings of fact, unnecessary hardship would not result from strict application of the ordinance. Because the uses, operations, and demand are the cause for the desire to construct an additional drive-through lane, the applicant could redevelop the site to accommodate a different layout that handles drive-through service demand. Chick-fil-A has done that in other locations throughout Charlotte. They've renovated, torn down, and built new buildings to accommodate different drive-through functionalities. Hardship does not result from conditions that are peculiar to the property. The property is a rectangle. It's approximately 242 feet wide by 226 feet deep. It's flat, and it's developed with an existing Chick-fil-A drive-through and parking. And there are other out parcels in the Rivergate Shopping Center area that have similar shapes and sizes and configurations. The hardship does result from actions taken by the applicant. Hardship result from actions taken by the applicant because the desire to construct an additional drive-through lane. The requested variance is not consistent with the spirit, purpose, and intent of the ordinance, and that public safety is secured and substantial justice is achieved because the conditional CC zoning district requires a 35-foot setback along public streets. Setback can be reduced down to 17 feet. The ordinance does allow you to reduce that, but only if certain criteria are met, and such as not having parking and maneuvering between the building and the street. And so a reduction to add additional vehicular movement in that space does not meet the intent of the allowed reductions in the zoning ordinance. There are multiple drive-through uses in the CC zoning district area with similar shapes and size lots in the immediate area and in the broader Charlotte jurisdiction. And drive-through service demand generated by Chick-fil-A doesn't constitute a hardship from the ordinance or the property itself. And that concludes staff's presentation. There's a picture of the sign on the property on exhibit 14.
So John, staff's position is that they should tear it down and rebuild.
Yes. We had initially advised them to try seeking a rezoning, and they went and spoke to the rezoning staff and basically was told that a rezoning probably wouldn't be supported by staff. So they still could do that and seek a rezoning to CG. And the CG zoning has different setback regulations that could allow them to have that second drive-through lane, but it would require that process of going through city council to get a rezoning approved. And they felt like it was unlikely that they would get that approval based on the feedback that they got from planning staff.
Their hands are tied. So their only option is here or to tear it down.
Correct.
Can you go back to the aerial, please?
Which one you want to see?
Anyone? Yeah, that one's good. So where are they backing up right now?
So as you can see this on some aerial imagery, and I didn't include it in the presentation because, just the history of how they operate, I figured they could talk about. But right now, the way they've got it is they block off this drive lane right here, and the traffic comes in around. There's a driveway here in front of the Best Buy building. And so traffic comes in here and pulls in, or if the line's not backed up past that point, they can come in and, come around this way or navigate through the parking lot to get into that drive-through lane. But it starts here and then wraps around and exits here.
And is it staff's position that there's any kind of safety issue by widening those drive-through lanes?
I don't know that we have any safety concerns for it. We just feel like that with the zoning that it is and other places that we have CC zoning, that this would not meet the intent of the ordinance by allowing that reduction in setback to create additional, like I said, additional vehicle movement within the setback. And the ordinance, like I mentioned earlier, the ordinance does allow ways for you to reduce the setback in CC district, but it doesn't allow for there to be vehicular movement between your building and your street if you're going to reduce that setback.
But in theory, it would in some ways reduce the traffic if there were two lanes. The traffic wouldn't back up quite as much if there were two lanes.
If this was on
Theoretically.
if this was on a public street and the backups were occurring into the public right of way, then staff might have a different feeling on that, but it's all internal to the shopping center and the Chick-fil-A property and the surrounding shopping center property. So there's not an impact to the public right of way in this case.
Are there streets in there that have a smaller setback in Rivergate?
Solon's probably the most familiar with the Rivergate Shopping Center plan. I don't know what.
I believe Rivergate Parkway is the only public one through there for this portion, and it might be Walker's Branch. It might be. Let me still, man.
Yeah, we'll go back to that one. To the left.
So that one at the top
This-
there,
The next one to the left.
that's private.
That's a private.
Yeah, this is
street.
private. This is private.
That's
This is
public.
public. And then obviously those are the public streets as well. I think this is
also-
private, Solomon.
Yes. Yes. And I think we also want to remember that when the conditional plan, remember, it was something staff, it was something that they negotiated with council at the time it was approved. And the reason why, like when we went to the UDO and we did not update those conditional districts, that was an agreement with the development community that when you got a conditional plan, it locks you in with those ordinance requirements for that infinite period of time. And we have to be careful because why I think staff, we were in opposition was if we approve this, we have CC that's all across the city and everybody's going to come in. We were concerned that everybody will start coming in and asking for variances to minimum standards that people agreed to.
But almost all of the rezoning approvals are conditional today.
I don't want
Most
to,
of them are.
I don't want to say they're all conditional. I mean, I think what happens is the intent of the comp plan in the UDO was that we were going to go away from conditional, but ultimately, if you're inconsistent with the adopted land use plan, they will typically staff will ask you to go to do some type of conditional rezoning.
Just to be clear, this was conditionally approved 20 years ago.
2004,
2004.
that'd be correct.
So a lot changes in 20 years.
Yeah.
That is true, but I think we also have to be careful of it's difficult for staff to go out there and say, hey, because my operations is changed 20 years ago, it would be you as a property owner still get those rights from 20 years ago. Because again, as part of our negotiation, we have conditional plans that are from the 50s and 60s still sitting out there. And I have to still allow that property owner to have those rights, even though maybe it may be time to change that zoning, but that is not something that staff has looked at because council has been they have not been very receptive to that sometimes.
Understood, but an alternative that you're not saying is that you can go back to council, rezone a property. Here, they don't have that option.
No,
I mean, they
they
could.
do.
They have the option.
They have the option. I guess we got to say is they received something from staff, from the rezoning staff that said they would not support it.
Understood.
But again, you can still file rezonings. And because there are things that staff doesn't support, that council approves all the time during the conditional rezoning process.
I think we have speakers in favor. I don't believe anyone in the audience is here to speak in opposition for this case. So I'm going to pull up the applicant's presentation if y'all are ready for that.
Okay, thank you.
It's conditional for the whole shopping center. Do they have the ability to get these in just for their parcel?
Mhm.
Okay.
We've done that, and we have done that in shopping centers where someone has come in and they've changed, and we've allowed just that property owner to.
Yes, sir. Thank you.
Joe.
All right, sir, but I'll have to swear you in and then I will ask you to state your name and spell it for the court reporter. Okay, do you solemnly swear or affirm that the evidence you shall give to the board in this action shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, please state your name and spell it.
My name is John Carmichael, Carmichael. 600 South Tryon Street, Suite 2300, 28202.
Thank you, Mr. Carmichael. You may continue.
Thank you. Once again, I'm John Carmichael, Madam Chairwoman and members of the board. I'm here on behalf of Chick-fil-A with me tonight, or today, excuse me. I'm used to doing zoning hearings. With me this morning are Megan Codwell of Chick-fil-A and Casey Durden, Chick-fil-A's engineer. Chick-fil-A is the owner of this 1.26 acre site located on the northeast corner of the intersection of Rivergate Parkway and South Tryon Street. The address is 14111 Rivergate Parkway, and the tax parcel number is 219-06124. And as Mr. Kenley said, this is a part of the Rivergate Shopping Center on South Tryon Street. The site is improved with approximately 4,900 square foot restaurant building, a drive-through lane, a drive-through window, surface parking and related improvements. The building does include a dining room, and the building was constructed in 2006. This is a view into the site from Tryon Street. And then this is a view into the site from Rivergate Parkway. South Tryon Street is on the left edge of the picture. So the purpose of this slide is just to show you some of the adjacent uses and get a little more context with respect to the shopping center, South Tryon Rivergate Parkway. This is the Chick-fil-A site. Mattress Firm is here. And then this is a building that is a multi-tenant building that has Best Buy, Office Max, Marshalls, and PetSmart. And that building sits on its own parcel of land. It's not owned by Chick-fil-A. It's owned by the shopping center. So the site is zoned CC Commercial Center. And as Mr. Fortune stated, it was rezoned in 2004 by the city of Charlotte in connection with the rezoning for Rivergate, the Rivergate Shopping Center. This is just a zoomed in aerial of the photo of the site. Casey, you want to come up? Could you state your full name?
Yeah,
Oh, you gotta
wait,
get sworn
I
in.
need to swear him in first.
You want to get our?
Yeah, we'll get.
Yes, everybody that's going to speak. Do you solemnly swear or affirm that the evidence you shall give to the board in this action shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay, all right, if you'll state your name and spell it for the court reporter if you're going to speak.
Casey Durden, with Hill Foley Rossi, 3680 Pleasant Hill Road, Duluth, Georgia, 30096.
And spell your last name, please.
Durden.
Thank you, Mr. Durden. And you, please state your name.
Yeah, Megan Caldwell, Meghan, with Chick-fil-A, 5200 Buffington Road, Atlanta, Georgia. The zip is 30349.
Okay,
Casey, could you just really briefly, what's your educational background?
So I'm a civil engineer. I've been doing this for 30 years plus, with Hill Foley Rossi.
Okay, employed by Hill Foley Rossi. Do you regularly design sites for Chick-fil-A?
Correct. We've done 100 plus for I can count.
And you're familiar with the subject site?
I am.
Have you actually been to the site?
Yes.
Okay. And did you prepare the plans that we'll share with the board
I
this
did.
morning? Okay. Can you briefly describe how the drive-through functions now?
Sure. So today it's 2 lanes, and then this point here, it merges down into 1 lane. And that's a choke point that's going to keep cars backing up. They've got cones here, they've got cones here. And these cars at peak time, sometimes they'll back up all the way through here. So what we're trying to do is put about 11 extra vehicles in the queue to help the queue in the status and get rid of this merge point. Also, this drive under the proposed plan would be removed, which would help flows in and out. But all of it's trying to be a good neighbor and keeping traffic from backing up on the adjacent properties.
And the point of order is here in the canopy, under the canopy?
Correct.
Okay,
Yes.
okay.
all right, tell me again where you're going to exit the cars.
And so we'll show it here in the site plan. In
Okay.
a second, it'll be a little quicker, but
Okay,
There we
you prepared the site plan, correct?
yes.
Can you briefly review the site plan, including Chairperson Dryden's question?
Sure. So this was that access point you were just inquiring
Right.
about. And what this is doing is allowing traffic. You can see these cars are a little darker. We're still preserving the walls and the landscape in there between the buffer. But we're adding 11 extra cars and then queuing people up back this way versus this way. So when they exit, there's a downstream constraint too. So you got your food, they can put cars downstream. That helps the flow, increases capacity.
Okay. So this is just a zoomed in portion of the western edge of the site so that we can focus on the variance that's requested. So Casey, what is the 35-foot number
So
reference?
that's right away to existing curb.
Well, this is the 35 feet is the setback, correct?
Correct. 35-foot setback.
From the setback under the CC district is measured from the property line or the right-of-way line. So it's 35 feet from the property line into the site. Under the new UDO, setbacks are measured from back of curb. So this is the setback line. And then this 27-foot dimension, Casey, that represents the distance from the property line to the outer edge of the second drive-through. Is that right?
Proposed second drive-through. Correct.
So that would be an 8-foot encroachment into the right of way, to the setback, correct?
Correct.
And then the 42-foot dimension, what does that reference?
That was from existing face of curb to proposed face of curb.
Of the second drive-through lane.
Correct.
Okay. Okay. So as Mr. Kinley stated, we're asking for an 8-foot variance into the 35-foot setback from the property line as required under the CC zoning district. That requirement is found in 11.4052 of the legacy zoning ordinance. Once again, this site is governed by that legacy ordinance because it was rezoned in 2004 and it is a conditional rezoning. So these are pictures that I took at the site very recently. This shows the existing condition, and Mr. Kinley had a similar photograph. This is the existing single drive-through lane located between the building and Rivergate Parkway. This is applicant's exhibit 10. This is exhibit 11. This is a different angle showing the same thing, but you can see outbound traffic on Rivergate Parkway, the existing planting strip and sidewalk, the knee wall, street trees, and then trees on the trees and shrubs on the Chick-fil-A site. And then this is across the street. This is looking from the other side or the western side of Rivergate Parkway into the Chick-fil-A site. And you can see this is the single drive-through lane. These are shrubs. And then this is the southern edge of that knee wall. Got the street trees here. And then you're just moving further to the north. That's the knee wall. You can see the cars in the drive-through lane. And then Casey, this is a rendered version of what Mr. Kinley shared, but this is a cross section you prepared, correct?
Correct.
That shows the relationship of the existing drive-through lane, the proposed second lane, and then Rivergate Parkway, and then the streetscape, correct?
Correct.
Can you just briefly
Sure.
talk about the
So-
relationship?
Sure. So this is your 27 and 35 foot. When we did look at rezoning, there was a bypass lane requirement.
I'll get into that.
Okay, we'll get into that here in a minute, but you still got preserved green space in this 23-foot lane.
So, but I think what's key here is both lanes sit below the elevation of Rivergate Parkway, correct? And the sidewalk.
Correct.
So right now the cars, obviously, the tops of the cars exceed that, but nevertheless, the floor of these lanes is below the elevation of the parkway and then the streetscape improvements. Now, would the installation of the second drive-through lane impact the trees, knee wall, street trees, or sidewalk?
It should not, no.
Okay. And
All
so
right, my question is, it should not, but what about the root system of that trees? How much are you gonna tear up the root system?
So we've got an enhanced landscape plan prepared. You know, we were originally trying to permit this as a site permit and came into these issues. So there is an enhanced landscape plan we're developing and happy to do any kind of landscape or replacement that's needed.
And you
Well,
certainly,
yeah.
so go, and one thing I would say is we certainly won't impact the street trees. And if the board is so inclined, and this is if, underline if, please, if the board was so inclined to grant the requested variance, then Chick-fil-A is certainly willing to add enhanced screening, landscaping, whatever the board would think would be justified to, in connection with the potential granting of that variance. So that's certainly on the table. There's been mention of what have we tried to do other than come here to this board to get a variance. So we did look at rezoning the property to a district under the UDO. And I looked through the UDO and the only district I found, and I could be wrong, don't think I am, but I don't know, even if I was wrong about the district, it doesn't change the requirements. But the only district I found that could possibly work is the commercial general district. And in looking at that, once again, it has a smaller setback than the commercial center district. Commercial center is 35 feet from the property line. The commercial center setback is 36 feet, the back of curb, okay? So measuring something from the back of curb makes the setback go less of a distance into the site. So that seemed like it could be a possible solution. But then in looking through the requirements, the new UDO would require a third lane, a bailout lane. So this is a plan that Casey prepared showing the site being improved under the CG district. You can see 2 drive-through lanes and a third lane that's the bailout lane. And this is a zoomed in portion of that plan. The second lane would comply with the setback requirement. The 36 feet is measured from back of curb. The issue is the bailout lane would not comply with the 36-foot setback requirement. It would encroach 8.9 feet into that 36 feet. So if we were going to rezone the site to accommodate a second drive-through lane at this location without scraping the site, assuming we got it approved, of the rezoning approved, we'd still have to come back to this board for 8.9 foot variance rather than the 8-foot variance that we're requesting. So that seemed to us to not make a whole lot of sense because it would have a larger variance, and you'd have the impervious drive-through lane closer to the street than the second drive-through lane under the proposal. And as Mr. Kinley stated, we also met with the planning staff in terms of the rezoning team, and they were clear that they would not support such a rezoning request. This is not a site that they want to be zoned commercial general. So that's why we're here. We did look at that. And unfortunately, that was not a solution. We were hoping there was a legislative solution, but there is not. Casey, in terms of, there are many reasons, and I'll get into them, and we'll try to be efficient here. Thanks for your patience. We think there are several reasons for not scraping the site and redeveloping it. But one of them is the site is not that wide. And you also, this is the property line. This is not part of the Chick-fil-A property. So are there challenges to scraping the site and putting in the 3 lanes that would be required?
Certainly. So, the first off is parking. We have a master agreement with parking. We have Megan can speak into this in a minute, but all these tenants have to sign off and approve any modification to the site. And this impact on parking, I think today how many parking spaces? We're like 41 spaces today. They may have 25, 30 employees. So we go to a tenant and say, hey, we're going to take off 10 more parking spots. That tenant's going to say, no way, you're already parking all over me and you're impacting my traffic movement. So, and Megan will confirm this in a minute. The plan that we're sharing tonight has been approved by the tenants and the shopping center. So that was also a separate process. I don't have any further questions for Casey. Does the board have any questions, or John, do you have any questions?
I have a couple questions. First of all, did you do the application, Mr. Carmichael?
I did.
I want first to commend you on a model of clarity on the application.
Oh, thank you.
I wish they were all as clear as that one. My second one is the UDO change from property line measurement on setback to the curb measurement is not, it's not very much here. Is that correct?
So you mean the delta
difference? Yes.
Yeah. So that's a great question. I was just telling Megan that I didn't take math in college. Yeah, I think it's here. Casey, you understand the question? So the UDO. So
what is the setback?
So the UDO is 36 feet from the back of curb. So the question is, what's the delta between 35 feet from the property line and 36 feet from the back of curb?
Yeah, roughly 2 feet, maybe.
A couple, it's not very much.
Right.
It's not material. Not enough to cover this.
Right.
Trying to understand if the UDO moved the goalposts on you enough to.
Yeah, the big thing was the third lane that's required. That's
for CG.
For any drive-through, as I understand it, under the UDO, it's 3 lanes.
Even for CC?
Yeah. Any drive-through use in the UDO is required to have a bailout or pass by.
So when we're looking at the rezoning is not just the 2 lanes, it's the 3 lanes that's required. And the 3rd lane is why we would need a variance even if we rezoned it.
And if you scrape the site, then you're gonna lose parking spots,
Yes.
correct? Okay.
We'll have to get permission from the adjacent property owner.
And just to be clear, 11 cars in lane 2 is not just 11 cars that come out of the line. It's a doubling of processing, which means your speed on the queue is dramatically better. So it's not just eliminating 11 cars from the queue, it's moving 11 times 2 through the queue.
It eliminates that merge point.
Correct.
By its position.
This is what's happened all over the city with Chick-fil-A because they put in double lanes because of this fact that they are not only queuing up in main streets, which I think what staff is worried about, not here, but every place else.
Right.
But you're also processing double the speed, which helps traffic flow.
And Ms. Caldwell's gonna speak to the impact on the adjacent property owner. It's not a right of way, you're correct, but it does have impacts on the adjacent property owner. And you need more questions from Mr. Durden? He certainly will.
Thank you for your
Thank you.
So Megan, you work for Chick-fil-A.
Yep.
What do you do for Chick-fil-A?
I am the program lead for the Atlantic region. So what that means is I oversee the investment strategy for capital improvements for our existing restaurants in North Carolina and Virginia markets.
Is this one of the stores you're responsible for?
Yes.
And you're personally familiar with the operational history and the current operations? Okay. So when did the restaurant open?
2006.
Okay, let's see. Oh, yeah, sorry. Oops, there you go. Can you enlarge that? Sorry. So the green line is a property line, once again, correct?
Yes.
And Mr. Durden touched on, you have a non-exclusive cross-access and shared parking agreement with this property owner, is that correct?
Correct. It's non-exclusive.
And does that agreement specifically allow you to queue vehicles on that property?
No, it does not exclusively permit us to do that.
And you have a queuing problem out there? And have you fielded, or Chick-fil-A, or you fielded complaints from the property owner and the tenants regarding the queuing?
Yes.
And is it also in terms of the frequency of the queuing? Okay, and can you just describe what the issue is precisely?
Sure. So once the store opened in 2006, when we initially, if we were to operate it as it was designed for the drive-through to come in this way and stack, for this to be kind of like the entrance to the site. However, we quickly noticed that this is a short distance for queuing and ultimately gridlocks the entire site. Cars can't get off, people can't get into the parking. And then what that was doing was backing up everybody into this main access road and even sometimes back into the main Rivergate Parkway. So operationally, they've blocked this off from the drive-through and have encouraged the drive-through to stack this way, circulate this way. We even at one point had this as the circulation point, and then that's when the complaints started coming from the Best Buy and the shopping center, because again, all of our traffic was stacking in front of their access. So ultimately now we're trying to force cars to queue all the way back here. And what it does is it's providing, access constraints as well as blocking parking that we don't technically have rights over or exclusive rights over. So.
And how far back does the queue go?
So at some points it was backing into here, then it was backing up in here, and then other times it will back sometimes all the way back around here in front of the Best Buy.
And was the queuing problem exacerbated in 2020 with the pandemic?
Yeah, so prior to then, our drive-through standards were for single lane drive-throughs, and that was sufficient. That was our prototypical standard. And then after that, we saw like a significant increase in demand, not just like in sense of overall demand, but specifically in customers wanting to dine through the drive-through sales channel. So prior to, we had about 40% of the business was through the drive-through. Post is about now up to almost 60% of the business through the drive-through.
And when this site was designed and developed, the Chick-fil-A site, could that have been anticipated? I mean,
No,
okay.
I mean, in my opinion.
No, right. So we would submit that you couldn't have anticipated the pandemic. You couldn't submit the increase in drive-through demand from consumers due to the pandemic. And then what that did is that shifted customer choices, and the increased drive-through demand is not diminished. Is that correct?
Correct.
And so we still have the same demand, but we have a 2005 design and a 2006 construction. So as a result of those queuing issues, we've been seeking solutions, or Chick-fil-A's been seeking solutions. I just was helping with the potential rezoning of this, but y'all taken other measures to try to solve it, correct?
Yes.
You hired more employees?
Yep.
You created a second line for order taking, right?
Yes.
Orders are now taken outdoors, right?
Correct.
Okay, and you have technology improvements in terms of the order taking process, is that right?
Yes.
And I believe in 2020, you remodeled the kitchen so that it operates more efficiently and can get food out quicker.
Yes.
So we can get the food out quicker, but we can't get the cars through. So that's why we're requesting the variance, and they have worked, but they haven't solved the problem, correct?
Correct.
In terms of the queuing problem. Okay.
Can I ask
Please.
if this variance is granted, will the queuing line change? Right now, you're coming right in front of the Best Buy around the side of their building, I'm assuming, and around all those cars. Is that how you're getting them in there?
Yes, I think to Mr. Shea's point, honestly, what we focus on here is not only the amount of cars that we can get into the stack with the second lane, but it's the ability to deliver not only to just one lane of cars, but two. So when we focus on our operational throughput, and we've studying these across the country, the efficiency of consistently keeping the line moving is what prevents the offsite queuing. So we focus on what we call departure rate. So the amount of time, the speed in which we deliver the meal delivery zone, the speed in which we're delivering food and getting cars off is ultimately what is the limiting factor to the cars backing up and continuing to queue off site. So the more that we can efficiently and consistently move them through, the more that we're able to meet the demand and prevent this. I'm not going to say it's going to work 100% of the time, but we found that during peak hours, it significantly reduces the offsite.
Well, if I was a customer of that Best Buy, I would be happy because I could at least get into a parking space instead of having to get in the queue for the Chick-fil-A that I'm not buying.
And we have been through an extensive approval process with them. That's taken almost a year to make sure that they feel like they've had an opinion and feel satisfied with the proposed improvements.
John Kinley, help me understand. I'm concerned here the staff is not on board, so I'm trying to understand better. If you scrape the site, they're still going to have to meet parking space requirements, correct?
Correct.
And so is there a risk they will not be able to reach the requirements for parking if they scrape the site?
And they
They're
would
gonna have to shift the building over 8 feet, right? Or no, I'm sorry, they're gonna have to shift the 3 lanes. So you have to shift it over more than that, aren't you?
12 feet.
12 feet.
12 to 15, because we have a specific safety requirement in our drive-through. We have a minimum drive-through lane width, which which Charlotte also has. And then we have a design standard that requires us to have pedestrian walkways in the drive-through for safety. So it's even more so than just the lane width. It's that plus the 3-foot team member safety in both cases.
So if they scraped it and redeveloped under the current zoning, they would not have to have a bypass lane. They could get by with just having 2 lanes around the building. The other thing to consider is the dine-in part of the building that makes the building larger. There are Chick-fil-A models that have no indoor seating or very limited indoor seating, and so the building's smaller. So it just depends on the site layout and design, whether or not they would be able to meet that parking requirement under a redesign of the entire site.
And we also got to remember the shopping center is a unified development. So all the parking is the entire shopping center, not just one parcel.
Shared.
It's shared, yeah. When we reviewed it as staff, we take, for example, if they say I've got 50,000 square feet on the center and we divide that 3,000, we divide it all across and staff. So when you start getting into those agreements with tenants, staff, when we did our zoning review, does not look at those.
So just so I'm clear, staff probably would not raise a parking issue on this.
So yeah, when you take you take that standard, because it's like because I believe they are over 100,000 square feet down here. So we would take it that it's the highest, it's like 1 per 330. When they show me that they're meeting over the site, we move on.
We've we've actually looked at options that reduce the parking on our parcel, and it was denied by the Best Buy and the shopping center because they don't want us to further reduce parking.
These guys, they're in between a rock and a hard place, I think, guys.
Yeah.
You know?
I agree. All right, you have anything else?
Well, I'm just going to go quickly. You've been very patient, the
Okay.
factors. So one is unnecessary hardship. And we would say that the strict application of the ordinance leaves the restaurant in a position where it can't officially meet the consumer demand for drive-through service on the site. And the desire to use drive-through has only increased over the years and continues to do so. Absent the granting of the variance, at least in our view, we'll not be able to add the second lane on the site in an effort to alleviate the queuing issue. The hardship results from the size and width of the site. We can't add the third lane without the variance. The site is an out parcel of an existing shopping center with shared access and shared parking agreements that are subject to the approval of the adjacent property owner. So we feel like there's limited design flexibility, and demolishing the building and redeveloping the site presents some challenges, as Mr. Durden stated, but we also think that's frankly, unduly burdensome. This is a building that the kitchen was remodeled in 2020. And in our opinion, we think it would be economically wasteful to have to demolish the building. The variance request is 8 feet, but the streetscape on Rivergate Parkway will remain the same. And we can certainly add additional screening if the board feels that's necessary. They're just trying to improve an existing condition on the site that would benefit the adjacent property owner and its customer base. The hardship results from conditions that are peculiar to the property. It results from the items I just mentioned. It also results from the fact that when the site was developed in 2006, this situation could not, at least in my opinion, reasonably have been anticipated. The shifting in consumer habits has been very dramatic, as you all know. The hardship don't result from actions taken by Chick-fil-A. The hardships result from the increased demand for drive-through service and the pandemic, neither of which were caused by Chick-fil-A. I guess you could say they have increased demand because they're so good at what they do. And and I'm not trying to be a smart aleck, but they are a good business that provides a service that the community has responded to. And the community wants to go, for whatever reason, wants to go through the drive-through lane. And in terms of consistent with the spirit, purpose, and intent, this, once again, it would help mitigate a problem. Chick-fil-A has tried to solve this problem through the measures that Ms. Codwell mentioned, but it just hasn't gone far enough. We would not adversely impact the streetscape. Once again, everything remain the same. And then this drive-through lane would be, the outer edge of the drive-through lane would be 42 feet, 42.1 feet from the back of curb. This is further back than the setback under the CG zoning under the new UDO. So humbly, we don't think this is a huge ask in terms of the degree of the variance request, but we understand. Look, I respect John and Mr. Kinley, Mr. Fortune's view on this. We're just trying to do this to solve a problem. And we're happy to answer any questions. I know we've gone long. Thank you.
Has the site, this particular site, before you sit down, has it been redeveloped or rebuilt since 2006? I know you mentioned that you've redone the kitchens, but have you redeveloped it or rebuilt since 2006?
When it was initially built, there was only a single lane entry as well on the order taking side. So you see the double order taking canopies. So we increased that. So you have two, now you can take orders in 2 lanes, but you can only deliver food in 1.
Okay, but the building itself has.
In the remodel, we increased the kitchen, like, internal remodel,
Okay, but no outside. Okay,
not to my knowledge.
okay. Thank you very much.
And I'll just for the record, these are exhibits.
All right, board, do you have any more questions for the parties or the witnesses before we move into deliberations? All right. We'll now begin deliberations. I'll accept comments and thoughts? Mr. Davis, we'll start with you.
I'm still trying to process.
Okay.
All of that information. Would it be possible to go back to the image with the measurements? All of the different measurements?
You want?
That one.
That
will
one's
work.
good.
Yeah, that one's fine, at least for me.
Thank you.
Yeah, there's also a zoomed in version of that, I think. There's that.
Pretty much anything when, that one, perfect, yeah. But I agree, it feels like between a rock and a hard place, because like from this, it looks like essentially what we're talking about is half a car length or width.
Right.
Understand they had the difficulty of accommodating more customers. However, I'm looking at it more through the four factors that influence our decisions. And so unnecessary hardship would not result from the strict application because they can still continue as is. And the hardship does not result from conditions peculiar to the property. The property is in a relatively normal size and location and has normal topo, and the hardship does not really result. It does result from the action that they want to take because they want to increase the lane, and that well, the only thing is the requested variance is consistent and with the purpose of the zoning because that will improve the traffic flow of the area.
Okay. Mr. Williamson, thoughts?
It seems like the hardship is on the neighbors. And yes, it's on Chick-fil-A, but the hardship, if we don't grant the variance, is also on the neighbors because there's not a whole lot they can do to accommodate the demand.
I think I'm looking at it as a trade because I'm worried that staff is not in support of this, and I see why. But I think the trade-off of getting a second lane to the benefit of the neighbors seems to be reasonable, seems to be a reasonable trade-off. And the hardship of giving them 8 feet to accommodate this, I just don't see how that's I don't see how that's fair. I think it's a reasonable trade-off to give them the second lane and help that flow in that parking lot. To me, I'm with Marshall. I think the neighbors would benefit because it's the hardship. They're the ones who are suffering the hardship.
Okay, my thoughts. I understand, as Mr. Fortune talked about, with these conditional rezonings, that it's always a slippery slope when we change what the expectation is. But again, this board is asked to look at things not broadly, like what's going to affect it. We've been told over and over again, we need to look at each individual case and decide for each individual case whether it's appropriate to approve what the applicant is requesting. I do agree with Marshall. That was my question about the neighboring businesses. I know, I'm sure they're happy that Chick-fil-A is bringing traffic into their shopping center, but if I'm the business on the corner, I'm not so happy because my patrons can't get to a parking place to park, and if they do, then they can't get out in order to get into my business because of the way the traffic backs up and is rerouted through that. And even though Zoning looks at it as the total number of parking places. Evidently, the businesses in that don't look at it that way. They look at the ones that are in proximity to their business. I also agree that I think it's a good trade-off. I mean, I am worried a little bit about the trees. And I do want to make sure that if there is damage to the tree that they're saying they're leaving because of the construction and the elevation, that we conditionally say that it has to be replaced or there has to be shrubbery that we continue that that's streetscape.
Make that a condition.
I'd like to make that a condition, yes, that the tree is either replaced or appropriate shrubbery. I know you're talking about enlarging the retaining wall, probably because of the elevation. So those are my thoughts. So with that said, do I hear a motion to approve this variance or to deny this variance? Yes, sir.
That which trees you're referring to.
Okay,
Rivergate side.
the Rivergate side.
The
The-
trees between the street
yeah.
and
The crepe
sidewalk, or
myrtle.
the trees that are behind the knee.
No, not the knee wall, the ones between the driveway and the wall.
The crepe myrtles.
Yeah, the crepe myrtles, and if there's another picture, I can tell you, show the one with the different elevations.
There's these
Yeah,
trees that.
right.
Crepe myrtles that are behind the knee wall.
Yes,
And
that's
then
the ones
there's-
I'm concerned, not those, they said there would be no damage to those.
That's what I
So
figured. That's what I thought.
yes, I'm concerned about the crepe myrtles that are there. And, the condition is that they either replace those, well, I'd like to, if they're damaged in the digging and the expansion of that lane.
Thank you.
Uh-huh. All right.
So
Do
board
I-
members, sorry if
Yes,
I may,
please.
as you deliberate and make your decision, I just wanted to remind you that under the statute and the ordinances, the variance runs with the land.
Correct.
So we want to make sure that you're considering under the standards that the hardship results from conditions that are peculiar to the property, such as location, size, or topography. Those are just examples. And that hardships resulting from personal circumstances, that's as well as hardships resulting from conditions that are common in the neighborhood may not be the basis for granting the variance. So just wanted to throw that out there for some additional thought or discussion related to whether the hardship results from personal circumstances. Remember, it should focus on the land, not the circumstances of the landowner, because that variance does run with the land. So any subsequent purchaser. So just wanted to throw that out for consideration as you make your decision.
But in a way, it does result from its location or maybe its size, because because of the traffic flow and the safety issues of all those cars in the parking lot. Because do look at those standards very carefully, because we're gonna have to rewrite them if we approve this. And we're gonna have to be firm in our reasoning for. And it can't be because I feel or I think. It's gotta be something that's definitive.
Yes, the question is, if this were a freestanding site that was the ingress and egress was from a city street instead of through a parking lot, would we grant that variance for one reason or another? Because part of the hardship in the peculiarity of the property is that it is accessed from a common parking lot.
Right. Well, probably for me, if it was off of Main Road, I would be more apt to approve it because traffic then would back up into those major thoroughfares. And I've been in those spaces in Charlotte, whether it be a restaurant or, I mean, that's why they redid an aside, they redid the Park Road Chick-fil-A for that reason, because it was backing up on the Park Road. And whether it's there's lots of schools, there's a lot of things that back traffic up that make it very dangerous because people don't realize what they're coming up against. So if it was a streetscape, I would probably be more apt to approve it to ease that traffic flow on those major thoroughfares.
I feel like we're still, like, whether it's a public road or a private parking lot, though, we're still talking about public safety.
Correct.
And I agree with the location. It is different because it's like this separate parcel, like
Right.
nestled in the corner. One barrier is a public parking.
Correct.
So
And I understand the conditional zoning issues. But I also realize how much the city has changed since 2004. Do we need demonize a business because they're successful? Because that's what this amounts to. They're successful, so they need more. But I know that's something we can't consider, but it's just in the back of my mind. Okay, any other discussion? Okay, guys, we need to make a decision. Is there a motion to approve with the conditions? The condition of the tree.
I'd make a motion to approve with the conditions.
Okay, thank you. Mr. Williamson,
And for the record, could you please state the condition?
With the condition of,
John, you want to read it?
sure the
Tree, yeah,
crepe myrtles are maintained and saved
or
and replaced if damaged.
Along Rivergate.
Right.
Can we say replace with a tree, I mean, the official trees, it's just right now, crepe myrtles are not.
So
Yeah, well,
a better
yes.
tree.
Better tree. Is that okay, Ms. Sanchez Myers?
Did someone write that down? Okay,
Say trees.
Yes, that's fine, just trees, yeah. Yes, that'll be fine.
I'll second that motion.
Okay, all right, I have a motion by Mr. Williamson to approve this variance with the condition concerning the trees. Mr. Shea has seconded. All right, Mr. Davis,
Davis, yes.
Ms. Sun,
Yes.
Mr. Shea,
Say yes.
Mr. Williamson,
Williamson, yes.
and Dryden, yes. So the variance is approved.
Madam Chair.
Yes, ma'am.
With respect to the board adopting findings of fact, we may want to ask the applicant if they have prepared any proposed findings of fact for the board. Just as a reminder, that is an option if you'd like the applicant, since they've been successful in gaining their variance, that they could prepare proposed findings of fact for the board's adoption. That would have to be adopted at the next meeting, but
Okay.
that's an option for the board unless you want to try to.
Yeah, I think that I would like to request that you prepare of finding of facts and conclusions of law based on what we've discussed here today. And based on the 4 standards. And if you can prepare that, and then we'll have it to vote on next week as a board. Next month, I'm sorry. Yeah, not next week, next month. But we have approved your variance. Okay, thank you very much. Thank you, Ms. Myers. Welcome back. We've missed you. Okay. All right. So we approved with conditions. Okay, oh. Ms. Montesquieu will, all right, the next variance is number 2025-00013 for property located 1804 Stony Creek Lane.
All right, this is for the Sikh Heritage Society of Greater Charlotte. It's represented by David Murray for the property located at 1804 Stony Creek Lane. And then it is a variance request to reduce the landscape yard required for N1A zoning in Article 20.9, Table 20-2 of the UDO. To reduce the width of that landscape yard from 25 feet down to 4 feet at the nearest point, which would be a 21-foot reduction. Grab a copy as well. Here's a map of the property. It's off of University City Boulevard and Mallory Creek Road. That's on Exhibit 1. Exhibit 2 is the zoning map showing the property zoned N1A zoning. Again, this is the parcel itself, and then the actual Heritage Society's building is here.
Big plot.
This is the aerial map on Exhibit 3. Shows the building, parking in this area here. Main driveway into the site is off of University City Boulevard. Stony Creek Lane is this road here, and there's a driveway curb cut that we'll talk about a little bit right there.
There's a, what did you say that was?
It's a curb cut,
Okay, got it.
like a driveway ramp.
Thank you.
And there's a better picture in a little bit. So the area that we're talking about is this area here, which would be where a landscape yard or buffer was required. Originally, when this was developed, this was all wooded, and you'll see that in these historical aerial images in a minute. So the close-up aerial is Exhibit 4. Exhibit 5 is the Google Street View imagery. This is University Boulevard here, looking towards the site. And you can see this is where the landscape yard would be typically. And this is a view from Stony Creek Lane. This is the driveway I was talking about off of Stony Creek, and they have a gate right here into this fence, and then drive and parking here. And typically the ordinance would require landscape yard along this fence line, basically. So the variance request is to reduce the landscape yard for the N1A zoning, Article 20.9, Table 20-2 of the UDO, to reduce the landscape yard width from 25 feet down to 4 feet at the nearest point, which is a 21-foot reduction. And the applicant has offered a condition to install an opaque screen fence with the reduced landscape yard area. And screen fencing is typically an optional component of a Class B landscape yard, which is the required class in this case. So in the event that the board did decide to approve the variance, the applicant has offered up that condition. Here's a survey on don't remember what exhibit this is. I'll shift this out of the way. Exhibit 7 is survey of the property. Again, showing this area down here where this parking is that eliminated the is where the landscape yard would be if it was had not been eliminated. And so,
All right, John, I'm lost, confused. All right. Right now, there's a driveway.
Yes, right now there's a parking spaces and a driveway that go through here.
What
So
are the parking spaces for?
For the Sikh Heritage Society.
Oh,
building.
okay.
So it's just, if I go back to the aerial, it's just it's an extension of their parking lot that they installed.
Okay, so what is it? What do they want to do?
So the request is to allow this to remain, basically, because the ordinance requires a landscape yard. That
Oh,
landscape
okay.
yard or buffer, in other words, was removed, and they installed this parking. And I'll explain when I get a little further into my presentation exactly how and why that buffer got removed.
Okay, thank you. I was confused.
So this is just the survey of the buffer, the landscape yard. The hashed line indicates where that 25-foot Class B landscape yard would be located if it was required and installed. And so you can see that it would remove basically access to this driveway point here. It would remove the parking and driveway that they have here, and then eliminate the drive aisle that would be here, and essentially render these parking spaces on this side of that drive aisle inoperable. And then they'd still have access to these spaces here if the landscape yard was installed. So going back in time, Exhibit 9, this is from 2004. So this is before University City Boulevard existed. And the Sikh Heritage Society had access off of a driveway coming off of what was the end of Stony Creek Lane at the time. None of these streets up here, this neighborhood to the north, didn't exist. And so then a little bit later, this single family neighborhood comes in, gets developed. They constructed a stub of what eventually would become Stony Creek all the way through. Still no connection here. Heritage Society still has connection off of Stony Creek Lane via their little driveway. Still no University City Boulevard constructed, and that's 2013 in Exhibit 10. And then jumping ahead to 2014, here comes the construction by NCDOT for University City Boulevard. And you can see that during construction, they maintain a kind of a dirt gravel driveway connection down the Stony Creek. But you'll notice here, all of this has gotten removed, all these trees that were here. So this is the area we're talking about, this area that's kind of lighter shade. DOT used that area to store materials for construction, park equipment and vehicles on. So basically all of that got removed during the construction of University City Boulevard. And then all that was left in this area was the neighborhood's area of common open space, which you can see if I go back to here, is this area. So the trees that you see in that 2014 aerial are the trees that are in this area here. Here are the lots for those single family houses. And all of this is what got removed by NCDOT during the construction. So all those trees here are gone. And that's Exhibit 11. Jumping ahead to 2017, Exhibit 12, University City Boulevard construction has ended. Stony Creek Lane now connects all the way through with a stop condition intersection. They have a driveway that they installed and NCDOT permitted along with CDOT, I guess maybe, because I think that's City Street. But anyway, they got permission to have that driveway there. And the trees are still gone from that area. So NCDOT didn't they didn't have a requirement to plant back the trees. So they just left it as it was after construction. I think maybe they put down grass seed. Then in 2018, Exhibit 13 shows gravel in that area. So the Sikh Heritage Society brought in some gravel to try to provide some additional overflow parking, utilizing that space that had been cleared by NCDOT. And then jump into 2020 on Exhibit 14, they paved that area, further establishing that parking in that area, formalizing that parking. And then this is what you see out here today, essentially, which is a few parallel parking spaces in this little area here. And then once you get around this corner where it narrows down, you got a double row of parking with the driveway circulating around it. And all of that, again, is within the area that would have been required as a buffer to the single family neighborhood over here.
All right, now, but if we uphold what you're suggesting, there would be still some parking spaces there and they would still have access to University City Boulevard, correct?
You go back to this plan. So, yeah, they would have access to this parking.
Right,
And then they still have access to
Right.
University City Boulevard off of this driveway. They just wouldn't have
So,
access to there.
how did
if
this
the
come to
variance is-
our attention?
So the applicant reached out to staff because they got a notice of violation.
Okay,
From code enforcement about having basically about the buffer being removed. I think that occurred in October of this past year. So October 2024 is when they were notified of that issue. And so, trying to get that resolved, they came to talk to us, and basically the conclusion was, well, you could seek a variance to the code requirement to reduce that landscape yard down to allow it to remain. Here are the standards for granting a variance under the UDO. All four of these have to be met, and I'll give you a chance to look at the findings before I move on.
okay, you can continue, John.
All right, so unnecessary hardship does not result from the strict application of the ordinance. While the landscape yard was removed by NCDOT and not restored by NCDOT, the applicant could have left the area as NCDOT had left it, or they could have replanted the area to meet the landscape yard standards rather than formalizing the area for a parking lot. The hardship does not result from conditions that are peculiar to the property. Subject portion of the property is an odd shape and is located between University City Boulevard and common open space. However, if the parking was not installed there, there would be space to install the required landscape yard. This is in my way. The hardship does result from actions that were taken by the applicant. It's true that the applicant did not remove the trees in the landscape area, and NCDOT did use that area for construction, parking, and material storage. However, the road construction project was completed and the applicant then placed gravel in that area and in 2019 paved it for parking. The requested variance is consistent with the spirit, purpose, and intent of the ordinance in that public safety is secured and substantial justice is achieved. NCDOT did construct a driveway curb cut to the applicant's property from Stony Creek Lane. And with that, with the variance not granted, there would not be a way to access this driveway if the landscape yard was installed. Without the secondary driveway on Stony Creek Lane, the applicant only has one way in and out of the site via the driveway on University City Boulevard. And having that access to Stony Creek Lane does benefit the public safety if emergency access is needed. Parking spaces within the landscape yard do not face the abutting residential uses, and it does directly abut a 27-foot plus wide area of neighborhood common open space and not the individual residential lots. The applicant has agreed to offer a condition to install an opaque screen fence with the reduced landscape yard area, and that screen fencing is typically an optional component of a Class B landscape yard.
John, the UDO hasn't changed this at all, has it? Since they dated in 19?
I think the pavement might have been done prior to the UDO going into effect. The legacy ordinance also required buffers between non-residential uses and residential uses. I don't know what the delta was between the legacy code and what the UDO requires here in this case. Probably less because the legacy code based it on total acreage of a site. And whereas the UDO uses for Class B landscape yard, at least in this instance, it's a set 25-foot width requirement.
But the applicant didn't make any advances to the zoning department when they decided to gravel this and pave it. I mean, they didn't.
I don't know if they sought any
Permits.
sort of land development permits. That would be something you would need to ask the applicant.
Okay, thank you.
That's correct. We don't have a land development permit for this.
Okay, a land development permit. Okay. Thank you. Anything else, John?
That is all I have.
Questions for John? Okay, we have somebody to speak. Okay, if you would all step up to the mic, please, as we swear you in. Do you all solemnly swear or affirm that the evidence you shall give to the board in this action shall be the truth, the whole truth, and nothing but the truth, so help you God? All right, if you will each state your name and spell it for the court reporter, please.
David Murray, Murray, 5950 Fairview Road, Suite 710, Charlotte.
Sajan Dhaliwal, Sajjan Dhaliwal, 2141 Hastings Drive, Charlotte, 28207.
Tom Giblin, TOMGIBLIN, 8500 Scouts Way, Charlotte, 28277.
Thank you very much. Okay, Mr. Murray, I assume that you're making the presentation.
Yes, thank you, members of the board. David Murray, Murray Law Firm, here to represent the Sikh Gurdwara. This is an aerial picture, exhibit 1 here of the property as it exists today. We have some more updated pictures than the city provided, so this is very picture heavy today so that everyone can see what's going on out at this property. The variance request, as John stated, is to basically allow what exists today to exist and remain, with the addition of a opaque fence to provide further screening. We would be here for this variance whether this was done or not. And there's reasons whether the parking was already there or not, as you'll see the hardships from lack of driveway and impact to the area where this buffer would be located. So it's 4 feet at the narrowest point. It's about 8 feet at its widest point as it exists today. And that would be the buffer that's on my client's property. And there's a HOA tree save next to it. So you can see the property is very uniquely shaped. The focus area down here is kind of the hockey stick, I would say, that's down here in the corner of the golf club, whatever we want to call it. And so this on exhibit 2 is the area next to University City Boulevard. This shape was created by the DOT's project. You can see what's interesting about it is the right-of-way is actually not straight. It actually creates a pinch point because of the taking by the DOT for University City Boulevard. This area adjacent or to the north of the property is a recorded tree save area for the HOA. So no residential structures can be built in this area. And I'll show you the plat for that in the future. But the fence line is almost on the property line here. I know the Polaris lines are not perfect, but it's pretty close. And so the existing fence, if you just kind of follow that green line, is pretty much where it exists today. This is an aerial from last year showing that fence. And that fence is a good marker so that you can kind of have a frame of reference, because that's the area that the DOT cleared up to when they took every tree that existed within the area of this property. And so this was cleared out by the DOT. The DOT installed this driveway. Sajan's here with me. He originally purchased this property and donated it to the Sikh temple. And he worked with NCDOT and CDOT to secure this was actually in the NCDOT's plan without us asking for it. And then went forward and had discussions with CDOT about this driveway entrance. So that was added during the NCDOT project in 2015, not by the applicant. And the feedback from CDOT and NCDOT was this should just be an emergency or a service entrance. And that's why you see that the arrows point out, not in. No one comes in this property that way. And honestly, there's very few times that this is even used for parking, maybe 4 times a year. It's essentially overflow. And these are just 4 parallel spaces. I think I said 2 later on in the presentation, but it's 4. And so if you're looking this at an aerial looking down at the property, this would be what you would see for the focus area that we're talking about. This is Exhibit 4. So the history again was all this landscaping buffer area was removed by NCDOT as part of the road construction project. The shape of the property is a result of the NCDOT project because they took a portion of the property and that's what left the hockey stick. And when the DOT used this area, they actually put down gravel. It's hard to see in the aerial pictures, but they were driving over it so constantly that red clay ended up covering up the gravel. So it's not as obvious, but they used it for storing materials, storing equipment, parking trucks for the construction of this property. Afterwards, it was left with the rocks and gravel in place under the red clay. It was unstabilized. There was no effort by the DOT or anyone to go back in to reestablish anything. And the members of the Sikh temple saw that DOT had cleared it and had been parking there. And so they decided, hey, we need overflow parking 4 times a year. And that's why we're going in there to establish and do what they did. Obviously, I'd love to be here saying we'd like to have this variance before we do anything, but they saw that it was already cleared and they came in and they established a drive aisle in those 4 parallel parking spaces. There's no parking in the buffer except for those 4 parallel spaces. Exhibit 5 is the original.
Right, I'm sorry,
Yep,
Mr. Murray, can
sorry.
you go back, can you say that again, what you just said?
So
Only 4 spots?
only the parallel spaces are actually in the buffer.
I thought the other, can you go back to the picture?
Yeah, there's a drive. I'll if you want me to advance, I can show you, but the 25-foot buffer
Right there.
only impacts this entrance. It goes through here. This is the brightest pointer ever, but
Hallelujah.
it goes through here. It pinches here, so you can't access over here once it's there. And then it goes up along here.
I thought that was the buffer right there.
That
as well.
is. This is the buffer.
So that asphalt is in the buffer.
That asphalt's in the buffer, but nobody's parking in it. It's just a maneuvering aisle.
But it would affect those parking spaces, wouldn't it? They wouldn't be able to back out.
It would affect the use of these parking spaces if that drive aisle was eliminated, yes. And again, this is mainly overflow parking. It's not, I went out of there, didn't tell Sagen I was going out there on Sunday because I just wanted to see for myself if anybody was parking out there, and nobody was. but it's overflow for events that they have approximately 4 times a year. So the buffer goes to the northwest of the slanted parking spaces, comes down, almost pinches at the DOT jut out in the right of way, and then comes across, pretty much kind of follows to the south of those arrows and encumbers the entrance.
So it's more than 4. It's more than just those 4. It's the other side.
Oh, yeah, yeah. So, I mean, there's 4 spaces in the buffer. It's gonna impact more than 4 spaces outside of the buffer because the usability of this single double row of parking would be impacted. And again, the parking in the location where it is, if the buffer wasn't, if the buffer was not an issue, there's nothing wrong with this parking being located to the front in the location where it is on the property. It's just simply that landscape area, the way that it runs, given the shape of this property, and given the alternate access that is causing the issues here. So Exhibit 5, and Mr. Kinley went through some of this, but Exhibit 5 and Sagen put together this presentation originally. This shows the existing before University City Boulevard. Exhibit 6 shows the development next door with all the trees existing in the buffer and along their driveway, the applicant's driveway. That's 2007. Exhibit 7 shows an outline that he prepared showing where University City Boulevard is going to come. Now we have University City Boulevard happening. DOT's already starting to store materials. They've cleared all the way up into the area that we currently have the parking today. This is Exhibit 8. Exhibit 9, it's hard to see, but they actually put gravel down in this area for their staging as they're building. This would be a DOT put the gravel down as part of their construction. So it's hard to see what date that is up there. I think it's hard to see, but it's Exhibit 9. Here's an aerial picture of the DOT actually removing all the trees. Here's all the trees piled up. And you can see that area is cleared. The area that we're focused on now, the fence line being a great marker, and the DOT's excavators out there actually clearing all of this area and up to the fence as part of the construction. This would have been in approximately 2015, Exhibit 10. And so now you have the curb line reestablished. This is Exhibit 11. The curb line reestablished, the driveway installed. It was granted by CDOT and NCDOT for a service emergency access easement, drive. In this area, this area is still cleared, open, red clay. The DOT planted some bushes along the front here. The applicant, as you'll see in some pictures, has planted over 200 trees on this property. And the city's pictures show it very open. It's much more heavily screened and vegetated today. This Exhibit 12 is the actual NCDOT plan that shows the NCDOT's driveway that was installed as an exit only into the property. You can see Sajan's name is on here. He was the owner before he dedicated it to the applicant. And in discussions with CDOT, it was limited to a service entrance. Exhibit 13, I might have actually doubled that up, but this is in 2017. Then in Exhibit 14, this is approximately 2018. The applicant added gravel to the area because it had been open and they were reestablishing and working on their parking lot. which had been impacted by the DOT as a result of the construction. COVID happened. And in COVID, this was paved. And some additional trees were added by the applicant. This is exhibit 15. Exhibit 16 would be how it is today with the trees from the HOA tree save area being this green area between the parking and the back of the existing houses. Exhibit 17 is the survey. City showed this as part of their exhibit. This is our survey. Exhibit 18 is a zoomed in of the area. The lot lines for the adjacent residential properties are measured here. The rear lot line for exhibit 14 is 47, almost 48 feet away. That corner with exhibit 15 is 53. For 15 and 16, it's approximately 70 feet. For 17, it's 42. And the closest lot line to the area of disturbance is approximately 35 feet. So all of these are more than 25 feet away. The eastern, kind of northeastern stretch of the parking where the double row of parking is, the fence is not on the property line. It's approximately 8 feet off the property line. So behind that fence is natural area. That's where it's more than 4 feet. It's closer to 4 feet on the area on the kind of the leg or the toe that comes out behind the lots that happen to also be further away from this property. Exhibit 19 is just another zoom in of the area I'm talking about with the distances to the residential lots. Exhibit 20 is the adjacent subdivision plan. What's really interesting about this tree save area is the tree save for the adjacent subdivision actually goes completely around this property. And so the whole property is buffered by a tree save that was dedicated by the developer when this was constructed. And you gave it. And you would be Sagen. Do you want to expand on that? The tree buffer? You contributed to that, correct?
They had just approached us as good neighbors. They wanted some tree save area. And I told them we have plenty of land and I love trees. I'll be glad to deed it to you. That's what we did. Go ahead.
Yeah. And so exhibit 21 is the tree buffer that exists along this property that's dedicated to tree save and a recorded easement. Mr. Shea, this goes back to what we were talking about before. The exact location here, exhibit 2022 is the exact location of this buffer. You can see there's a pinch point where the line L7, L6, and L5 of the DOT right of way come across. So if the variance is not granted, the driveway entrance onto Stony Creek or the exit service entrance, it's actually in the landscape buffer today. Any parking that, or really any use of this tow area is eliminated. It's a dead zone in that area. And then the impact on the adjacent overflow parking, that's the double line, single row of double line parking would also be impacted because the maneuvering aisle would be eliminated by this. I call it a buffer. I think it's a landscape yard, I think is the actual term. This is a picture of it as of Sunday. This is the fence. This would be looking at the neighborhood, the exhibit 23. Exhibit 24 is a close-up of the fence. You can see there's been a lot of vegetative growth over this fence over the years because it hasn't been disturbed, hasn't been cleared. They keep it natural. Exhibit 25 is looking to the HOA property. This is a densely wooded area. And because it's natural for the HOA, it stays very opaque on its own. The chain link fence exists in that picture. Exhibit 26, another picture of the fence a little bit more exposed, so you can see what the existing fence looks like. Exhibit 27 is looking at this double row of parking, looking back towards the neighborhood. You can see the existing trees. Exhibit 28 is kind of looking northwest, I guess we'd say, kind of up the row, back up towards the neighborhood. Exhibit 29 is showing that pinch point that I mentioned before, where the DOT's right-of-way comes in and the drive aisle moves through. One other thing to note here, the University City Boulevard is below grade of this property. So when you're driving by the tree screening, you really don't notice that this exists because it's actually above your field of view. And then this would be the exit onto Stony Creek, the driveway. It is gated to make sure that people are not freely using this. This is Exhibit 30. Exhibit 31 is looking from that entrance back towards the property. You can see the screening, the HOA property, as well as the 4 feet of existing screening and planting that exists there today, as well as those plants and trees that were planted back in 2018. They've grown up a lot now. Another view of the driveway, you can see it's grown up a lot more than those pictures that were provided by the city. This is Exhibit 32. Exhibit 33 is what you would see if you're at the intersection of Stony Creek and University City Boulevard, with the trees that were planted by the NCDOT at the front, the trees that were planted by the applicant on their property beyond the fence and beyond the right of way. And then the tall trees are that landscape buffer, the tree preservation area for the HOA behind it. And then again, another view under Exhibit 34 of the trees. And then finally, the last picture, Exhibit 35, of the tree buffer for the HOA area and the fence. And then this would be a view if you're standing, the Exhibit 36 is a view if you're standing on University City Boulevard, and this would be the area of the parking lot next to you. So the grade is a bit uphill. 37's a view looking down at that grade. So the variance standards here, as you all know them well, is we have to have an unnecessary hardship based upon conditions peculiar to the property, does not result from actions taken by the applicant.
They did.
And it's consistent with what I call the 3 S's: the spirit, safety, and substantial justice. So the unnecessary hardship here is, without the variance, the driveway entrance on Stony Creek, the exit, that's the safety, that's the emergency and service entrance, will be eliminated. It will not be allowed because it actually exists in the buffer itself. Also, the western portion of that lot will be rendered unusable because of the pinch point created by the DOT's construction, as well as the impact to the parking areas that exist today. And again, this is overflow parking. This is not something that's used all the time. This is a house of worship. This is a use that is allowed in N1A. It's not an intensive use. And so this request is not about allowing parking where it's located. It's just solely about that buffer area. And this hardship would exist whether that parking and paving was out there today. The driveway is located there because of the distance that it has to be set back from University City Boulevard, which is why NCDOT and CDOT approved it in that location. And so that entrance would be impacted regardless if there was a drive-through there. Now, the pinch point it would eliminate any use of that area regardless if there was parking now. And then because of the unique shape of the property, the way it comes down, trying to get a single row of parking into where it's located would be impacted because of the lack of maneuvering in that area adjacent to the buffer. This hardship runs with the land. It is directly related to the DOT's impact on this property, which resulted in the unique shape of the property. None of that area was actually cleared by the applicants. This was something that was done by the DOT. The city completely agrees with us that the DOT cleared this area. When they cleared it, they left gravel, and so they began to use that area. But again, anybody that owned this property would have the same hardships because of the shape of the property. What else is interesting about this is the location. The way the UDO works is even though there's over 25 feet of tree save immediately adjacent to this property, and even though there will be no residential uses in that area, it still requires a 25-foot additional buffer. And within position of that buffer, you impact negatively the use of the applicant's property for maneuvering and for the entrance to the property. It's not a self-created hardship. The shape of the lot was created by the NCDOT as part of their construction process. The NCDOT cleared all this area for staging and parking. The driveway location was added because of the choice of NCDOT, and the shape of the property is going to require us to be here whether we had done this already or not. And so the applicant operated in good faith. They saw what the DOT had done. They saw the DOT had been parking out there, and they used the same area that the DOT had used. They did not expand beyond what the DOT did. They used the exact same area as the DOT. One other point that I'll add is this was brought to the city's attention because the applicants were looking at doing improvements to the Gurdwara that exists on the property. And when they brought that to the city's attention, the city realized that this parking area was in the buffer. And then the city issued a notice of violation. This was not based upon a complaint. This was brought because they were actually seeking permits to improve the property, and it was caught as part of that review. And so that's what brought us here. The clearing actually has existed for such a long period of time that we're really just here to bring conformity under the ordinance, under the UDO, because this parking has already existed. The clearing has actually been done since 2015. We're almost 10 years of that area being open out there. And then the three S's, as I said: spirit, safety, substantial justice. The safety part's straightforward. There's not any safety issues here with the way parking is done. Parking could be located here if there was not the landscape requirement. The additional entrance is something that is important. This is a place of worship. It's a place of assembly. Having an alternate entrance is important for circulation of this site as well as for getting in and out of the site. What's interesting about the neighborhood here and what's interesting about the property is, again, it has the HOA common open space that's been recorded and dedicated. So there's not going to be this narrow shape area is not ever going to have houses on it. And the HOA property next door is never going to have houses on it. This is solely for the overflow circulation of the site. And it's extremely well screened. As far as the spirit and the intent piece of the puzzle go, the intent of this buffer is that if you have a place of worship and you have a residential house next door and they share a property line, have some kind of screening buffer so that the parking is not immediately on top of that house's property. And that doesn't exist here. There is a recorded plat with the buffer for the HOA next door. And so we believe it meets all the standards here for granting this variance. And happy to answer any questions. Sagen has a lot of knowledge about this. He's been out there before anything was developed. He's worked with the adjacent developers and made sure that it's a nice looking area. The other issue that we run into is, as you can see in the pictures, this is a very, this is a very heavily wooded lot. And so if the parking and access is eliminated, in order to get more parking, we're going to have to clear a substantial amount of trees to do additional parking on this area. And ideally, it would be great to preserve the trees that exist today. Happy to answer any questions. Yeah.
The latest picture of the front, how it looks.
I'm not sure that I have all the pictures, but there's a picture shown.
Any questions for Mr. Murray from the board?
John, how important is access to Stony Creek to staff?
In CDOT and in CDOT installed and they constructed Stony Creek Lane in the intersection there, so they apparently felt that it was warranted and needed to have the driveway there. I mean, from a planning perspective, just in general concept of planning, having multiple entry points into a parcel is good in case something were to happen at the main intersection. So I think it's beneficial, not required, though.
Okay. And their address is on Stony Creek, and if they lost the driveway, they would have no access from Stony Creek.
Yeah, it's
Kind of odd.
And Sagen, you adopt my testimony and presentation as if it's your own, correct?
Yes, sir. This was a beautiful property that we had. And when the road came in, city caused us a lot of hardships. And we worked with them as much as we could. And after they left the complete front, nothing but mud. We took upon ourselves to stabilize it. I put more than over 200 brand new trees years ago. If you go there now, it's like a beautiful park. It's so nice. You can't even see from the road into it. And as far as the buffer is concerned, the existing fence has so much vegetation and trees on it. I don't think it needs any other ugly fence in front of it. It is beautiful as it is. You can't even tell. And as far as the buffer is concerned, I don't know in what way the use of that land really affects anybody. Only 4 times a year for 3 hours or 4 hours, that area would be used. Otherwise, it lays empty as it is. On Sundays, as I see cars parked on all the corners of the city. So this is a very, very private property. And whatever you all can do, it's up to you. We have done our part. Thank you.
Thank you.
Thank you. Mr. Murray, I'm having a hard time getting by number 3. This is self-inflicted wound.
Yep.
I don't see how you can get around that. I'd like to make a suggestion that having access to Stony Creek is important to me. I think that having 2 accesses are important. I'd be willing to suggest to the board that we waive the buffer requirement on that left side of the pinch point So you have access, that driveway is access. But the right side, I'm having a really hard time. Just because ignorance of the law doesn't allow you to get away with it. I mean, I think that's still in violation. So I would not be in support of waiving that buffer requirement, but to the left of the pinch point, that allows you to keep your driveway. You lose your parking, but you have access and you have a second way in and out of that place. You lose 4 parking spots. You shift over a little bit. I don't think that's a dramatic hit to you. But I'd like to make that suggestion.
Where would you pull back to? Just, because even if we did at the pinch point, it's still, you see what I mean? There's like an angle.
Yeah, so exactly at that pinch point, left of that pinch point.
Basically here. Left.
No, down to the bottom. Yeah,
Okay.
right there, up to that vertex, yep. That left side, I think it's a hardship that you don't have to suffer through. But the right side, you've self-inflicted.
Well, we can't get through because this exists.
That's what I'm saying. You leave that. I'm okay with that. So you have Stony Creek access. I think waiving the buffer requirements for that, so you have the driveway access, so there's a second access to the property. To me, that makes sense. This is my opinion. But to the right side, I mean, staff's completely right. I mean, it's just a self-inflicted wound here and
Are you saying remove the buffer?
yeah,
To get through?
just assume everything stays the same on the left-hand side from the pinch point.
Yep.
The right side, we need the buffer. So where your driveway, yes, where those parking spots are to the right, you're gonna lose that
I
backside.
follow what you're saying. I'm just saying to get connectivity from here to here. This impacts that.
At the pinch point.
Can't get through. Yeah, I hear what you're saying. I was just saying. It would have to be pulled back a little bit more than that to be able to get.
Whatever staff is comfortable with, I'm okay with that, but I
Also, sorry if I may, even if we remove 20 feet of asphalt, what we really gain from it? Hardly anything, because there are no trees here. We did not cut any trees. DOT did. We were given a site which was very, very bad shape. They destroyed for us. And we made it, really established it, replanted the tree, the grass and the whole thing. And cutting that asphalt 20 feet back, what way does it affect anyone?
Sejan, hold on one second. Can you give us 5 minutes to talk through this?
Yes.
Awesome.
All right, we're gonna take a 5-minute break, well, more like 10, please.
10's fine. Let's talk real fast because.
Thank you. Take your seats, ladies and gentlemen. Just coming. Thank you all. The meeting will resume.
Yeah, I have a revised exhibit 22 that I'll submit to the board to take a look at.
All right, thank you.
I think this incorporates what the discussion was from past it on. But basically, from the tip of this parking spot
Okay,
to that point, the buffer remains and is reestablished.
okay,
From the tip of that parking lot to this point, downward, the variance that would be the variance.
staff is good with that? Yes, to maintain the driveway. All right,
Make a motion to approve that.
all right. Thank you. Mr. Shea makes a motion to approve. Wait.
Okay, sorry.
Yeah, what do I, how do I?
We closed for deliberations. I think we're still, there's
Oh, I'm
Yeah,
sorry. I
we're still
apologize for that.
evidentiary
Moving along.
piece.
Okay, anyone else need to speak? Gentlemen, are you satisfied with
Yes.
everything? Okay. All right, no one else has to speak, so we'll go into deliberations. All right. No? Oh,
I mean, I live there. Okay, so you can't care to speak on this, because I think there are people here.
okay. All right, thank you, gentlemen. If you will step aside a moment, I have someone else who would like to speak. Okay, I need to swear you in, please. Do you solemnly swear or affirm that the evidence you shall give to the board in this action shall be the truth, the whole truth, and nothing but the truth, so help you God? All right, if you will state your name and spell it for the court reporter, please.
Lauren Williams, Williams. And I just need clarification, that's all. I was reading along when he was doing his presentation and I saw something that says he wanted to do an expansion. I just want to make sure that I'm understanding that what he has now is there. And I don't really have a problem with that because it's already there, but I want to know that going forward, he's not trying to push it back further.
That's not the discussion.
No,
point
that's
today,
not the discussion we're
unfortunately.
having today.
Perfect.
Yes.
Your question, if they do an expansion, they would have to go through they would have to go through a land development review, and then we would make sure that they are meeting the standards of the applicable board is times.
Okay, perfect. And then I would get notification.
Yes.
Yes. All right, thank you very much. Okay, has everybody had a chance to look at this? Is that good? So,
I'm totally fine with that.
yeah, from here to here. Okay, so this is all gonna stay the way it is and this is gonna have to be rebuffered. Correct.
John, we can, as part of our approval, can we use okay.
Yeah, you should refer to that revised. I think we labeled it as revised exhibit 22.
Okay. Okay. All right. Mr. Shea had made a motion to,
I'll do it again.
okay,
I'm
go.
make a motion to approve.
Sorry. If you, just for the formal process, if you could close the evidentiary hearing, go into deliberations, is there any other discussion? I believe when you started to discuss, Mr. Shea spoke up, but I don't believe any of the other board members had an opportunity to say anything. So we just, they concur, that's great, but we just want to make sure that the board's reasoning is reflected through your deliberation and discussion.
Okay,
Thank you.
thank you. All right, we will now go into deliberations. Okay. All right. I was very concerned about this as we started the hearing. Because of the closure of the access, I do think it's important, especially with an area as large as this, to have a secondary emergency exit if it's required. I do believe that the hardship to some extent was caused by the applicant. I know they were trying to do what they thought was right, but they did pave over an area that was supposed to be a buffer. All right, Mr. Davis, do you have any comments?
I agree. I feel like treating this essentially as two variance requests, where the first one, you have that point of egress. It to me makes sense to keep that, but you can also maintain the landscape buffer. I'm using the improper term there, but so I feel like it's still keeping with the UDO. But it's also working with the conditions that were kind of handed to the applicant. So I feel like the revision to exhibit 22 is kind of the best solution on both of those fronts.
Thank you. Ms. Sun?
I agree.
Mr. Williamson?
I agree.
All right. Okay. All right. Yes, please make a motion.
I'm gonna make a motion to approve the variance with the condition that revision 22, illustration 22 is part of the approval.
Does that work?
Is that okay, Jill?
Okay. Yes, sir.
Does that also include the condition that the petitioner offered up regarding the fence, the big screen fence?
It should, yes. Yes, per the original agreement. Yes, that's here, that the applicant has offered to a condition. So, all right, so you need to amend your or continue with your recommendation that you approve it based on the revisions to exhibit 22 and the condition that the applicant has offered. Number 20.
Third time's a charm. I make a motion to approve with exhibit 22
Revised.
exhibit 22 and item number 20 from the finding of fact. Sanchez Myers.
Do we need to restate the condition?
Yes, just for clarification, let me see if this is what you're
Okay.
trying to move. I believe Mr. Shea was trying to make a motion to approve the variance based on the revisions to exhibit 22 with the additional condition that the applicant would install an opaque screen fence within the landscape yard area. Is that correct?
That work? Okay. And I'm gonna take out the word, this says within the reduced landscape yard area. I'm gonna say just within their landscape yard area. Does that work for everybody?
Yes.
Okay, all right, so Ms. Sanchez Myers has reread Mr. Shea's motion. Do I hear a second?
Davis, second.
All right, thank you, Mr. Davis. All right, Mr. Williamson,
Williamson, yes.
Mr. Shea,
Say yes.
Ms. Sun,
Done, yes.
Mr. Davis,
Yes.
Dryden, yes. So we have approved this application with a revised edition, revised exhibit 22, and that the applicant will install an opaque screen fence within the landscape yard area. Thank you. All right, do you guys, you need this back? Okay. All right. Okay,
Chair, the board will also need to adopt.
yes, we looked at finding of facts and conclusions of law, please.
Mr. Murray has some proposed findings.
Thank you, Mr. Murray.
So you may need to do a
Yeah, when
hybrid of staffs or
pass it on to staff. Okay.
Madam Chair.
Yes.
Since this one is a little bit more complicated, perhaps you might want to ask Mr. Murray if he would come back with some proposed findings of fact that incorporate both staff's and his findings of fact, since there was sort of an.
Yes.
Findings deal heavily with the area that we cut out.
Okay. So would you do that for us for our May meeting? Okay, so we will table the finding of facts and conclusions of law until our May meeting. And Mr. Murray will return with amended finding of facts and conclusions of law for us to look at. Thank you, Mr. Murray. I appreciate it very much. Have a good day. You. All right. Our next case is variance number 2020. I'm sorry, so
So good. Just keep.
everybody, yeah, I think so. Yeah, since we had a break about 30 minutes ago, it's okay. I'm good for another hour and a half at least. Okay. Okay. Variance number 2025-00018. Okay, Ms. Montague, you're on.
So everyone, this is case number variance 2025-00018, Andre Jennings for property located at 6306 English Elm Court, owned by Andre Jennings. Variance request to Article 4.3 from setbacks for N1A zoning. In Article 4.3, Table 4-2 of the UDO, to reduce the rear setback from the required 40 feet to 32 feet, an 8-foot reduction. Exhibit 1 shows a vicinity map off of Ridgemore Drive, north of 485. The zoning map in Exhibit 2 shows that it is N1A zoning, Neighborhood 1 zoning districts in a cul-de-sac. Here's an aerial map in Exhibit 3. Exhibit 4 shows Google Street View of the property. The variance request is to reduce the rear setback from the required 40 feet to 32 feet, an 8-foot reduction. The applicant has offered a condition that the variance would only apply to the encroachment and its replacement or repair if damaged or destroyed by an act of God. Here is the home and the addition to the rear. It's built into the setback. This is the 40-foot rear yard here. And it says that it's 32 feet from the addition to the lot line. And Exhibit 7 shows the Mecklenburg County GIS building information. This is the finished upper story, the basement, and upper garage.
Utility garage, I think is what that's saying.
On the Mecklenburg County time machine, I know this is a bit blurred, but in 2004, this is previous to the addition, and post addition in 2007. Here's the variance criteria if you want to look over the findings of facts.
Figured that they could do that. All right, you may continue. Thank you.
Thank you. I wanted to mention that, just wanted to highlight in the findings of facts, number 8, staff and the applicant were unable to find any records of the building permit issued for the addition. Unnecessary hardships would not result from the strict application of ordinance because the back of the addition could be removed to be compliant with the ordinance, or the space could be converted into an unheated sunroom or porch, which would be allowed to encroach into the 40-foot rear setback by 10 feet. The hardship does not result from conditions that are peculiar to the property because there are not any peculiarities with the lot size, shape, topography, or placement of the home on the lot. The hardship does not result from actions taken by the applicant. The applicant inherited the home from his father and was not involved in the construction of the addition. The requested variance is consistent with the spirit, purpose, and intent of the ordinance in that public safety is secured and substantial justice is achieved. The encroachment has existed since at least 2007. The discovery of the encroachment is not a result of code enforcement action. It was discovered when the applicant acquired a survey on the lot when he inherited it from his late father. The encroachment is in the middle of the rear of the home and not visible from the street. Granting the variance will not alter the essential character of the neighborhood. And the applicant has offered a condition that the variance would only apply to the encroachment and its replacement or repair if damaged or destroyed by an act of God.
This encroachment, is it a screen porch? What is it? Do you know?
Screen porch would be,
No, it would be,
would not be okay. A deck would be okay.
a deck would be okay, but
So the ordinance allows for unheated extensions to a certain percentage.
right, yeah, yeah.
This is heated space.
So it's heated space. I mean, is it?
It's living space of the house.
Oh,
I don't know what it was originally when it was
Okay.
constructed, but the applicant may know the answer.
Okay.
That, but but for zoning's perspective, it's considered part of the heated floor space of the house and therefore is a violation.
I got it. Okay, thank you.
And here is the sign posted on the property. If you have any questions, be happy to help.
Any questions for staff? Thank you very much. And the applicant is here to speak. Okay. Everyone who's going to speak, if you'll step up, please. All right. Do you solemnly swear or affirm that the evidence you shall give to the board in this action shall be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, I do.
Okay, if you would state your name and spell it for the court reporter, please.
Matthew Jones. HEWJONES. Address is 1019 Thornsby Lane, Matthews.
Andre Jennings, ANDRE, last name Jennings, JENNINGS.
Thank you, Mr. Jennings and Mr. Jones. Okay, Mr. Jones, you're up.
You can control it with this and you.
All right, good. Thank you for your time. Hopefully this will be a fairly short presentation. I'll go through the conditions as they exist and then a quick summary of what you saw in the report. And thank you for staff for good findings and good report there. So again, front of the property, 6306 English Elm Court. And highlighted in green is the property line. The pink are the setbacks. The blue is the structure that was originally built. And then highlighted in yellow and orange is the addition that was built on around 2007. The yellow portions are outside of the setback. The orange is the encroaching portion that goes into the setback. This is a photo of the back of the property. That protrusion, the part that sticks out, is the portion that was added on around 2007 and is encroaching into the setback. Here is about the extent of the encroachment in the setback. So everything behind the white is outside the setback. And from another angle, the other corner of that same portion And again, the white shows where the setback would be. Everything behind that is outside the setback. And there is the property. So again, in quick summary, what we have here is a condition that was not caused by the applicant. His late father built this again around 2007, so it stood for almost 20 years. He inherited the property, didn't purchase it, didn't cause this, didn't ask for this, was not involved in the construction of it. But when his father passed away, he inherited this property with this condition in place. And again, being that it's been nearly 20 years, I know it doesn't meet the code requirements, but being that it's been there so long, as far as we know, there's not been a complaint about the addition that was added on from any of the neighbors. So we do ask that it be allowed to remain. In terms of hardship, while not necessarily being what staff or what the board might consider a hardship, it would be a financial hardship on the applicant to then remedy this problem. It would be a deconstruction or a tearing down or a pretty large alteration to take it back to unheated space. So that's a hardship that the applicant would not expect to have. And now if there are any questions, either of the applicant, who's now the owner, or myself.
What is the space now?
What is the space?
What is it?
What is it?
It was a bedroom.
It's a bedroom right now?
It's a bedroom.
Any other questions? Mr. Jennings, do you plan to speak?
No, unless one has a question. No.
Okay,
Don't mind
any
speaking.
questions?
May I close with one thing?
Yes, sir, you may.
As we have
Absolutely.
agreed and city staff, we talked about this. We are okay just limiting that variance to just the portion that's right around the structure. So no additional structure could be built. No further addition onto the back of the house. So that reduction in the setback to 32 feet would be fine if we could just put that right around that piece of structure that goes out into the setback.
And you do agree that the only replacement or repair would be if it was damaged or destroyed by
Yes.
an act of God? Okay.
Yes. I do got some additional comment, I'm sorry. A young man named Kenny lives in a neighborhood. He went by with all the neighbors and none of them had an issue with the addition on there. So he did go by each and every one of the houses.
Okay.
My dad was a member of the HOA in that community. He also had several pieces of property in that community. And I don't know why he would build something without getting the proper
Permits.
documentations. I don't know. I would love to ask him, be the first time I could prove him wrong, but you know, he's not here, but
It's all right. He wasn't the first
that's my 2 cents.
and he won't be the last, I'm sure. Okay, thank you. Any other questions for the applicants? All right,
John, just, can you refresh me? I should know this, and I just don't remember. If the variance is approved and the house burned down tomorrow, do they have the right to build 8 feet into the setback?
They would have the right to build it back the way it stands.
The way it is right now, the same footprint.
yes.
They couldn't alter it at all.
So, I mean, anything that would be compliant with the code, they could alter, but like, as far as like additional encroachments into the setbacks, they wouldn't be able to do that. So it would have to be same footprint or within the setback.
Gotcha.
All right,
Thank you.
thank you. Any other questions or comments? Thank you, gentlemen. All right, the board will now go into deliberations. I'll give you a moment to organize your thoughts and then we'll share. Okay, Mr. Williamson, any thoughts?
The only thought I have is, seems like I recall previous variance requests to build into a setback for a first floor bedroom due to various medical reasons or whatever for aging homeowners. So I'm inclined to approve it.
Thank you, sir. Mr. Shea, thoughts?
I don't know where I am.
Okay. Ms. Sun?
I agree with Mark.
Okay. Mr. Davis?
I'm still kind of mulling it over, but I agree that while the conclusion of law is that unnecessary hardships would not result from the strict application. I understand like that conceptually, but in actuality, for the homeowner who didn't do this, that would be a hardship. So I'm leaning towards approval, but I'm open to hearing the rest of deliberations.
I agree. I would support, I would support 100%, except now we have the ability, now we give them the ability to build, or somebody in the future to build into the setback, and that it is a tremendous hardship to rectify it now.
But they can only build into the setback where this building is. They can't encroach any further to the right or the left or to the rear. They can only, based on the number 16, which says the applicant has offered the condition would only apply to the encroachment and its replacement or repair if damaged or destroyed by an act of God. So, it's, and it goes with the land. So, I mean, it's not, nobody else would be able to encroach on it unless they came to us and asked for another variance.
Madam Chair, if
Yes,
I
ma'am.
may. As you're discussing and deliberating, I just wanted to point out, and I believe you've been advised of this previously, but that financial situation or hardship cannot be the sole grounds for granting a variance. So just keep that in mind, that the law specifically states that in case law. So you would need to be looking for other evidence that's been presented regarding a hardship in order to grant the variance.
Well, if we look at our standards, it says unnecessary hardship would result from the strict application of the regulation. And it says in the absence of the variance, no reasonable use can be made of the property. Well, that's pretty much true, because they can't do anything with it because it's in the setback. The hardship results from conditions that are peculiar to the property, such as location, size, or topography. I don't know. I have a problem with that one. I don't know if we can just say the hardship does not result. The hardship does not result from actions taken by the applicant or the property owner, and that's true. The applicant did not own the property when this was done. And the variance is consistent with the spirit, purpose, and intent of the regulation. And that substantial justice is achieved. I believe that this would be an unnecessary hardship. As the structure has existed for almost 20 years. So I would be inclined to approve this variance. Any other thoughts? Board? And do I hear a motion to approve this variance or deny this variance?
So a motion to approve.
Okay, Ms. Sun has made a motion to approve.
Williamson second.
Williamson seconds. All right, Mr. Davis,
Yes.
Ms. Sun,
Son, yes.
Mr. Shea,
Shay, no.
okay, and Mr. Williamson
Williamson, yes.
and Dryden, yes.
I'm sorry, I didn't hear Mr. Shays.
Mr. Shea was a no.
Okay, thank you.
All right. By a 4-to-1 vote, the variance is approved. All right, now we need to look at our finding of facts and conclusions of law and fix those. I think we're pretty good on the finding of facts. I don't see anything.
So Madam Chair, if I may?
Yes, please.
So I believe the draft findings of facts that you have, would support conclusion of law 3 and 4, that the hardship does not result from the actions taken by the applicant and that the variance is consistent, but you would need to, add some additional facts to support, the other two, that you would be finding the unnecessary hardships would result,
Yes.
and that the hardship does result from conditions that are peculiar to the property. So you would need to explain through your findings of facts and the evidence that you relied upon.
Okay. All right, so number one, we're okay with if we take out not. Unnecessary hardships would result from the strict application of the ordinance. What we need to deal with is number 2. The hardship would have to be does result from conditions that are peculiar to the property. That could we put in there that the existing structure was established 20 years ago?
And are you referencing the residence or the addition or both when you say this?
The addition.
Okay, the existing
The
addition.
existing addition. So it would be the existing addition was established 20 years ago. That's one of the hardships that we're identifying that are peculiar to the property. The hardship does not result from actions taken by the applicant. I would agree with that. Okay, is that enough or do we need to talk?
So you
about
need to look at
number
findings of fact number 9 and 10 would need to be completely reworded, eliminated.
Let's see, the hardship does not result. Sure, we're gonna back of that addition could be removed. Could we just remove it? Remove number 9?
Okay.
Number 9 to support your conclusion of law, unnecessary hardship would result. From the
Oh, okay. Okay, would result.
The number 9, as you suggested, taking on the word not hardship does result from strict application of the ordinance because, and then you need to add for rewords the rest of that.
Okay. All right, because that's where we need to put, because the existing structure, the existing addition was established over 20 years ago. Can we, that needs to be put there. And we take out, the back of the addition could be removed. Or the place in heated sunroom portrait would be allowed. Okay. So we're adding existing. Sure.
And number 10.
And number 10, the hardship does result from the conditions that are peculiar to the property. Because again, that the same thing, the existing structure was there 20 years ago. And that's basically what we're basing this on, the time the structure was added on. And did your father use that bedroom, sir?
Yes, ma'am. He used it because of the stairs as his age started to decline. He needed.
So, Jill, could we put something in there about, because the age of the applicant, access to bedrooms, is that something that could be a justification?
So
I
at
don't
this
know, I'm just
point,
asking.
I don't believe that was part of the evidence
Right.
presented, so you're kind of trying to back
Okay.
into
So,
the
okay.
findings of fact, so I
But
advise
are we
against
good with,
that.
with those two statements? You feel like that's sufficient, or do you want us to add something
'Cause
else?
the existing addition was established over 20 years ago. I mean, if that's the evidence the board is relying on.
Is that what is that okay, guys? You speak up. I'm doing all the talking here. I know you don't
I
want
wasn't in favor.
to, I know, I should. Mr. Williamson, help me with this.
I'm trying. The hardship does result from the existing encroachment that is peculiar to the property.
The hardship does not result from action taken by the applicant.
Right, that one where it's, but it's number 10, the hardship does result from conditions, we have to say it does result from the conditions that are peculiar to the property, because encroachment into the setback,
If they had built in its placement of the home on the lot,
right,
if he had built the home further to the front of the lot, he wouldn't have encroached in the rear.
okay, so could we say encroachment into the setback due to placement of the original home? Does that work, Miss Jill? Sort of? Kind of?
These are your findings of fact, so,
This would be for number 10. The hardship does result from conditions that are peculiar to the property because encroachment into the setback
Is a result of the placement of the home on the lot.
is a result of the placement
Structure.
of the original structure.
okay. And did you want to keep, you had mentioned earlier to add to that one also the existing addition
I
was
think
established
we can
20
just leave that in number
Gotcha.
9. I
Okay.
think that we're trying to differentiate between the two, so I think
Okay.
that would work. So that would be number 9, would be number 10.
Okay.
All right. And then we're good with the conclusions of law. Hardship would result. Hardship does result. Conditions peculiar to the property. Because the existing addition was established 20 years ago, or words to that effect for number 3. 2, the hardship does not result from actions taken by the plaintiff, and the variance is consistent with. Okay, the hardship does not result from the strict application of the ordinance. I'm sorry, does, I took out not, and I read it. From the strict application of the ordinance because the existing structure was added over 20 years ago. That was what we said for number 9.
The addition.
Or the existing addition to the structure, or do I have to put that addition to the structure? Okay, was added over 20 years ago. And then number 10 was going to read, the hardship does result from conditions that are peculiar to the property because encroachment into the setback is a result of the placement of the original structure?
Of the original home on the lot was what. I-
Original home on the lot, okay, however, home on the lot. Thank you. All right, now do I hear a motion to accept the finding of facts and conclusions of law as amended?
Davis, yes.
Thank you, Mr. Davis. Do I hear a second?
Sun second.
Ms. Sun, second. Okay, Mr. Williamson,
Williamson, yes.
Mr. Shea,
Daniel.
Ms. Sun,
Sun, yes.
Mr. Davis,
Yes.
Dryden, yes. Okay, so the variance is approved. Thank you, gentlemen. Okay, our next case is variance number 2025-00019 for property located at 315 Tranquil Avenue. I'm sorry. Before we do that, a point of order, Ms. Sanchez-Myers, did we have to, when we approved those finding effects, did we have to reiterate that with the condition? Because the condition was already in there.
It's already in there, so
So
it's
it's
part
okay?
of your
Okay,
written decision
thank you.
now.
I just want to make sure I should. Thank you.
You just pick your name.
Okay.
Same owner as the last one, or is that a?
No, this is just the last, then we have to go back and do the three at the top of the page.
Right, but I'm saying
Same owner. Yes.
owned by.
Oh, yeah, there was a,
19.
Here,
it's owned by Andre, here's owned by Andre Jennings.
yeah, but it's a different variance though.
But
Right, but I'm just saying, I think that's a-
Jennings. It's.
Oh,
a typo.
yeah, he said there were some changes to be made there.
Yeah.
Yes,
It's right in here.
yeah, on this case 19, the owner name on the agenda said Andre Jennings. It's actually 315 Tranquil
Okay.
LLC. Sorry for the confusion there.
Okay, Christie's. Oh, yeah. All right, you may begin, sir.
All right, this is a variance 2025-00019. Chris Deese, represented by Jennifer Ray. I think they're kind of co-applicants, but just for technical sake, that's how we worded it. For a property located at 315 Tranquil Avenue and owned by 315 Tranquil LLC. It's a variance request to Article 4.3B, Table 4-1, Line E for N1C zoning, which is a maximum building coverage percentage requirement to allow the 50% building coverage for lots less than 10,000 square feet to apply to a lot that's 10,102 square feet instead of the 40% building coverage that's required for lots that are 10,000 square feet and greater. So does that kind of make sense? You have a lot that's 10,000 square feet, your 40% maximum building coverage. If you are less than 10,000 square feet, then you get to use a 50% maximum building coverage. And so this lot is 10,102 square feet, and the variance request is to allow them to use the 50% rule rather than the 40% rule. This is the vicinity map of the area on Exhibit 1. We're kind of south of Hillside Avenue, north of Woodlawn, and east of Park Road. The zoning of the property on Exhibit 2 is N1C. Property's highlighted in green. Tranquil Avenue is to the north. Exhibit 3, aerial map of the property showing the existing house on the property. Exhibit 4 is the Google Street View showing the existing house from Tranquil Avenue. Exhibit 5 again is just the variance request. I won't read over all of that again. I think it's pretty self-explanatory what the request is. This is Exhibit 6 is just the survey showing the existing conditions on the property. So you have the existing house with a deck in the back and then a gravel driveway going back to, this is labeled as a pavilion at the back. Exhibit 7 is the applicant's proposed new build survey showing the setbacks applied to the lot and the proposed building coverage that they are proposing. This is saying that the proposed building coverage would be 4,444 square feet, which is 44% of the lot. So not quite the 50%, but more than the 40 that's would be required for this particular lot based on its square footage. Exhibit 8 is just the standards for granting a variance. All 4 of these have to be met. And a little bit of history or background. Get a copy of it. So what brings us to this point, basically, of the requested variance is that the applicant did request a administrative adjustment per Article 37.4, and that article allows staff to administratively address quantitative standards by a degree of up to 10%. So we had looked at doing that. It says that we have to notify the adjacent property owners abutting the property that's the request is being made. And there's one of 5 criteria that has to be shown to be met in order for that administrative adjustment to be granted. So staff notified the neighbors of the requested adjustment request, and the ordinance says that if those any of those neighbors object with the stated reason within a 10-day period, then the staff will consider those comments. And if they find that there could be some warrant to those comments, basically that the adjustment request is automatically denied, and the applicant then has the option to seek a variance. So that is why this request is before you all today, and it's not being handled administratively because they tried that and they got opposition for the administrative request, and thus they are now seeking the variance request. And when you're ready, I'll continue on with the findings.
All right.
So unnecessary hardship would not result from the strict application of the ordinance because the applicant could reduce the size of the proposed structure to meet the ordinance requirements. Hardship does not result from conditions that are peculiar to the property. The immediate lots abutting this property are just under 10,000 square feet. In the findings under line 9, we have a list of some of the square footages of the immediate abutting properties, and they're all under 10,000 square feet. And so they're able to use that 50% provision to allow 50% building coverage. However, if you look at the broader community and neighborhood, there's a mix of lots both under and over the 10,000 square foot threshold, and granting the variance could set some precedents by allowing lots that are just over 2,000 square feet to use the 50% building coverage requirements. So we don't feel like that would meet the intent of the ordinance. The hardship does result from actions that are taken by the applicant due to their desire to construct a new structure that is larger than what the ordinance would allow. Again, they could reduce the size of the proposed structure to meet the ordinance requirements. And the requested variance is not consistent with the spirit, purpose, and intent of the ordinance. We feel that granting the variance would again erode the intent of the ordinance to limit the building coverage on larger lots within the city. And I'll take any questions if you have any. I do believe we have speakers in favor and against on this case.
So this is for new construction?
This would be for new construction. That's correct. So the plan would be to demolish the existing house and build a new structure on the property.
And they need, because they're over 10,000, they need to stay within the 40%. Correct. Okay.
Then the difference is, I think I have that in the findings, if
less than 10,000 square feet?
Yeah, so per the ordinance requirement, the resulting maximum building coverage for this lot would be 4,040 square feet.
Right?
With the variance given, then, they could do 50% of that 10,000 or 5,000 square feet. I think what they're proposing on their site plan, again, is 4,444 square feet, which is 44%.
Okay, thank you very much. Any other questions for staff? All right, those who are going to speak, if you will step up to the mic, please. Yeah. Are you for or against, sir?
I'm the owner.
You're the owner. Okay, so do you solemnly swear or affirm that the evidence you shall give to the board in this action shall be the truth, the whole truth, and nothing but the truth? So help you God.
I do.
All right, and please state your name and spell it for the court reporter.
Christopher Deese. See.
Mr. Deese?
Okay, thanks. All right, thank you for hearing me. I'll try to be quick. So the request is to build 50% coverage for the first 9,999 square feet, 40% for the remaining. The variance, as John said, is for table 4-1 row E, which states lots 10,000 square feet and greater can build 40%. Lots 10,000 square foot and less can build 50%. So basically over 10,000 to infinity is 40%. Right under 10,000 is 50%. I'm basically 102 square feet above 10,000, which hurts me really bad. The hardship, I tried the administrative variance, it was denied. This is a loophole in the UDO that negatively affects lots like 315 Tranquil. The UDO was not created with lots just over 10,000 square feet in mind. It was just a break in line. If they'd have done, instead of 10,000, done 11,000, I wouldn't be here. If it was 12,000, I wouldn't be here. So I don't think it's fair that lots that are just a little bit smaller can build 25% more coverage. We're around 1,000 square foot. I can go back to an example from the aerial, which shows a lot directly beside 315 is just a little bit smaller and can build almost 5,000 square feet by right. And here again, I'm just a little bit different. And I don't think there's any reason a bigger lot should not be able to build same coverage as a similar lot in the same location. And here's the list of the 5 parcels that touch 315. And as you can see, every one of them can build more square footage by right. And I will point out 321, which is right beside 315, can build almost 5,000 by right. And here again, the lot was created over 100 years ago. Back then, they had no idea what the UDO, was going to be one day. So, it was not created with the UDO in mind. And in my mind, it's unnecessary to have to do this because it is a similar lot, same location. It's just the 10,000 number. For the variance to meet the proof that you need, the unnecessary hardship is the 10,000 number. And the hardship result was from the 10,000 number. The hardship is not a result of the owner, because here again, the 10,000 number was created out of thin air with the UDO. And I believe this is consistent with the code in the neighborhood. As I said, because all parcels that touch this parcel can do what I would like to do by right. And if anybody has questions, please feel free.
Have you thought about doing a simple sublotting so that?
If you do that, it creates, as I understand it, if you do that, it takes away all the current by right.
The what?
The current by right is what he said.
The current by right, not necessarily. That would be a question for Solomon.
I don't, subletting doesn't get you out of your building coverage. So. For him, it would still be, because think about it, sublot's really only for when you're doing like townhomes and you're doing that for sale aspect, but it would still be, you would still have that maximum building coverage of that entire lot.
Mr. Reese, as a licensed general contractor, I've been in your shoes, the guy. I can also tell you that the 10,000 square foot number, Solomon knows this better than I do, has been argued with, negotiated with, brought down, brought up. It used to be worse. 10,000, you actually in better shape than you could have been. At some of the other persons that argued against it won. So 10,000 square feet is where do you move the line? You just keep moving it and moving it and moving it. I can tell you right now that we moved hard to get it to 10,000 feet to help people like you and me. And so we have to play within those boundaries that we fought to create. And whether you were part of that argument or not, 10,000 feet is the floor we were given. That was the number that we were given. I think it's a fair number. We worked hard to get to that number. And so those are the rules supplied by the city. That's the rule we had to play by. If you have the ability, as a suggestion, if you want to slice off 102 feet and give it to your neighbor and come into a compliance, have at it.
I was told that would not work, because if you do that, that creates a whole new lot, and maybe Solomon can explain how that works.
I guess you're correct. In theory, it works, but what Mr. Deese is saying is yes, when we create those lots and you shave it off, you would still have to make sure that you are compliant with your lot standards for the underlying zoning district. Now, I have not looked at that option, so, but you're correct, Mr. Shea. You could, in theory, you could do that if you had a large enough lot.
So I'm with you, buddy. I feel for you, but
I don't know
the
that
rule, we moved those rules. As a GC, I worked hard to make sure I was part of that conversation to get that as most compliant for the building community, because we have a lot of 10,000 square foot lots in Myers Park. There's a ton of them. So we did the best we can, and those are the rules. And as much as I feel for you, there's no way I can support this variance.
Okay.
Okay, any other questions or comments from Mr. Deese? All right, is someone else?
Madam
yes,
Chair,
yes, please.
and Board Member Shea has raised some interesting points. I was wondering if staff could speak to that and provide some sworn testimony to bolster and support
the 10,000 square feet.
Yeah, just to help expand on what the point that Mr. Shea has raised, please.
So Mr. Shea is correct. When you go back into the previous ordinance, when we started creating those lots, we came up with a number so that way it was fair to everybody. And so what happens is, yes, I guess say if I was someone that said, for example, we set the number at 10,000 and you have a 10,001 lot, you're in that other category. And Mr. Chair is correct, when we started creating, and even with the UDO, we started some lot standards, and we were looking at, hey, these are the standard lots in each district. We looked at them across the board, and we said, hey, when we came up with that 10,000 square foot number, that was kind of the agreement between the development community and staff and everybody, because again, it was that, and I guess kind of telling people what the intent was when you had a smaller lot, yes, you may get a bigger building, but as you think about it, for example, I said, if I have a 5-acre site and you start saying, hey, I'm gonna build this 10,000 square foot home, that 40% you're not going to get nowhere near, because again, I've got a 5-acre site. And so that was kind of the intent, that, hey, the larger home you were starting to get, because again, what we were trying to avoid was, as you're seeing in certain areas of town where you're getting in the professional term, they call it the McMansions, where someone has maxed out that entire building footprint. And that was, and obviously that also coincided with some of our stormwater requirements.
But like I said, keep in mind where this particular lot is, all the surrounding lots will be developed bigger one day. This one will be smaller, and the square footage of the lot is actually a little bit bigger. John, can you go to the area where it shows the 5 lots?
Down?
Yeah, that's fine. So like I said, all the ones that touch, they can all build way more square footage than I came about, right? And if they want to get administrative variance, in some cases, they could build almost around 1,500 square foot more than myself. Same similar lots. We're talking about slight little difference in square foot.
Thank you, Mr. Dees. Any other questions or comments for Mr. Dees? All right, is there someone here to speak in opposition? Okay. Thank you, Mr. Dees. All right. Thank you, gentlemen. Let me swear you in, please. Do you solemnly swear or affirm that the evidence you shall give to the board in this action shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, if you would each state your name and spell it, your last name for the court reporter, please.
Sure. First name Robert, Robert. Last name Cochran, Cochrane.
And Joshua Mallet, JOSHUA, MALLUTT, sorry.
All right. Mr. Cochran, you're speaking first?
Yes, ma'am.
Okay.
Just click forward.
Yeah.
Okay. All right, I'll try and be quick because I think we're coming to a consensus here. It's lunchtime and I feel bad for whoever's taking minutes. So as you know, from my testimony there, my name is Robert Cochran. I live immediately adjacent to 315 Tranquil Avenue. Thank you for allowing me to speak regarding this variance request. As you'll see here on page 3, I, together with my neighbors, many are here in attendance, several are zoomed in, would request that the board deny this variance request. While we fully support reasonable development, this request does not meet the legal standards required for variance approval under the UDO. At its core, this variance is not about hardship, it's about personal design preference and profit, neither of which meet the strict standards under North Carolina law and the Charlotte UDO. Furthermore, it presents substantial risks to the neighborhood's character, drainage conditions, and residential privacy. So skipping ahead, this is our first argument that no unnecessary hardship exists here. So I'd like to point out that at the bottom of this slide, the applicant has sent me his detailed alternate plans that comply with the UDO and demonstrate that no hardship exists. As you can see, the plans preserve what is a duplex layout, and essentially the bulk of the floor plan would be preserved as well, simply by adjusting the structure's rear depth. The very existence of these compliant plans directly defeats any claim of unnecessary hardship. The applicant is dealing with an inconvenience, and that is not recognized as a valid hardship under North Carolina law. I'd also like to call out that approving this variance could set a dangerous precedent and open the floodgates to other marginal lot cases, and the last thing you need is another agenda item. All right. Next slide here. I think it's worth noting that the builder claims hardship because 315 Tranquil is larger than neighboring parcels. This lot, like the others touch it, is standard shaped and readily buildable without a variance. I'd also like to call out that we touched on, I think the staff here did, and the applicant, that each of the 5 neighboring lots is less than 10,000 square feet. I actually did some research and figured out you could look at each of the deeds for these neighboring lots, and 321 Tranquil, if you look at the old deed, it's actually over 10,000 square feet. And so I've got that cited there if you want to look it up at the deed book and page number. So that lot would also be subject to the same zoning requirements as 315 Tranquil. So with that, I would argue that the hardship claim based on lot comparisons my opinion, is irrelevant to the matter at hand, but it's also factually flawed.
Just give one additional supporting on this.
Yes, sir.
Point. So, I live across the street, 318 Tranquil, and many of the lots on the other side of the street are north of 10,000 square feet. My property is 12,981 square feet. If you were to apply the same logic of 40% up to 10,000, or sorry, 50% up to 10,000, and then 40% above it, that would have a building size of 6,200 or approximately 47% of the overall land. So just further substantiating that the overall neighborhood, if this were to be applied more broadly, would have a significant impact to our neighborhood.
Probably a good segue into an appendix slide. So we looked at 27 data points and used the tools at our disposal, sourced or cited down there. So that's the appendix slide. The summary is right here. So there are 11 lots in my sample, less than 10,000 square feet, 13 between 10 to 12,000 square feet, only a few greater than 12,000 square feet. The average lot coverage, excuse me, is 20.8% for the relevant lot size tier of 10,000 to 12,000 square feet. And all data points, that blends down a little bit to 20.5%. And so what the applicant has proposed would be 24% greater than that. And if you looked at just the building footprint alone at 4,444 square feet, that would be 80% greater than the average of all of these data points. It's not cherry picked. I just ran out of time and grabbed 27 before I went to sleep. So I think that speaks for itself. And then, a few additional points, and then I'll be quiet. The spirit and purpose and intent of the UDO, I think, is undermined here. I mean, there's a exact phrase in there that says the purpose is to preserve and enhance the character of structures and communities that constitute the distinct places within the city. I don't think that is the case here, and I think that approving this variance would enable construction of an oversized duplex. Each unit, if the plans I'm interpreting correctly, is over 5,000 square feet of finished space. And so if you assume 500 a square foot, each is likely listed at 2.5 million per unit. And so I just think that that is counter to some of the goals that we're trying to achieve over the next 10 to 15 years here in Charlotte around affordable housing. So those are the main arguments. I'll quickly hit just a few additional neighbor concerns. To the extent that we are able to get any additional safeguards to mitigate some of the negative impacts of this construction under contemplation. So the first would be stormwater concerns. The Polaris map here shows that 315 Tranquil is very proximate to floodplain areas, and the slope of the lot drains downhill to Chelsea and Wales, which is circled there in red, where we've had significant water issues. And so, even in the dead of summer, it's like you're crossing a river, and I don't know why that's the case, but I can only imagine that the issues would become worse with this construction. And, additionally, my own backyard, in our inspection report, it flagged that we've got drainage issues. It backs up to 315 Tranquil, and I've got in the corner at the low point some water issues, which that's my issue to deal with, but would point out that this is caused by the grade of that lot and the way the water slopes down to that low point I just discussed. We've already hit this point around how much this sticks out relative to the other lots and building footprints in our neighborhood. And then this is further evidence of that point. While the UDO states a 17-foot front setback restriction, all of our old deeds, there's a 30-foot setback restriction. And so when you look down Tranquil Avenue, you see that 30 feet of front space. This would, be built to 17 feet, which is allowed under the UDO, but further, undermines and takes away from the visual rhythm of our neighborhood. And then the last, major neighbor concern is just if you look at the before and after site survey here, I know it's a little bit of an eye chart, but the red box is the setback requirement. The green box is the building footprint on the left, that's current, on the right, that's proposed. And then kind of the shaded area off to each side is just kind of where you might consider privacy to be impacted. On the right, you can see it's a big change, and I personally live to the left and the shaded area. And given the grade and the extension towards the rear setback, they would be looking down through bedrooms and porches into my bedroom, my backyard, and my family room, which I'm not thrilled about, but that's not the reason we're here. So, in conclusion, we love our neighborhood and we want to protect its character and livability. We've got several neighbors here and support. There's no unnecessary hardship here. The applicant purchased the lot, knowingly caused his own problem through his design choice. The variance would threaten the character of our neighborhood above and beyond what is permitted under the UDO, exacerbate stormwater harm, and set a dangerous precedent for marginal lot cases. So we would respectfully ask that you deny the variance. And if you are at all inclined to approve any portion of the variance, we would add a minimum request that the builder complete a full independent drainage and stormwater runoff impact study, as well as any design concessions to mitigate privacy impacts on the neighboring properties. Sorry, that was longer than expected, but thanks for your time.
Thank you, sir. Any questions, board, for the, excuse me? Yes, you certainly can. Any other questions for, Mr. Cochran?
Solomon, I have a question. So building coverage is just the foundation part, right? It's not the total square footage allowed.
Building coverage is everything under the roof.
Okay.
That's heating square foot, obviously square footage, that counts towards building square footage.
So if you can still have more square footage by building more levels.
I mean, yes. But obviously what's gonna happen is now you're gonna get in some other requirements that are gonna start limiting what you can build.
In the residential area, you can only build so high. Okay, any other questions before Mr. Deese responds? All right, thank you, gentlemen. Mr. Deese, you may respond.
I'd just like to point out, both of the gentlemen who just spoke, they can both do what I would like to do by right. They prefer I not be able to do it. He had mentioned that the water runs off from 315 to his lot. I've been out there and I've seen it, and you can look on GIS. I believe it's 2 feet or more. Your lot is higher than 315. So it would be, I don't see how the water can go from 315 to his lot. And I'm not.
Yes, okay, we can take that under advisement, but you, since you're not.
And here again, we're talking about by right coverage line only.
Correct, okay. Any other questions for Mr. Deese? All right, thank you, gentlemen. All right, the board will now go into deliberations. Unless there are further questions for staff. All right.
I just want to confirm there are no other speakers
oh.
for or against. Here, John.
Are there any other speakers that would like to voice an opinion? Now's the time. All right. You have to come and be sworn in. It's all right, just walk around him. The table.
Quick comment is just because you.
No, you gotta come to the table and be sworn in. Do you solemnly swear to swear or affirm that the evidence you shall give to the board in this action shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, please state your name and spell it for the court recorder.
Carrie Tom, KAREYTOM.
All right, are you speaking against Ms. Tom or for?
Yes, I'm speaking against, I was just gonna make a quick comment.
Okay.
That just because you can doesn't mean you should. And we should take into consideration the amount of neighbors who do have the ability to build well beyond into their lot size and don't. That is my point.
Okay, thank you
Thank you.
thank you very much. I appreciate your comments. All right, anyone else wish to speak? All right. Thank you very much. All right, we will now go into deliberations. So you may take a moment or you may speak up, board. Well,
Being someone who lives downhill from someone who's overdeveloped a property, I would vote to deny this variance.
My feeling is, I appreciate the plea. But after hearing from, our zoning administrator about why they chose this figure. And I know it, it's sad that you say, well, I'm only 3 inches taller or shorter, but they won't let you on the ride at the amusement park if you don't meet the height requirement. And there's not anything you can do about that. And I believe that our request for the variant consistent with the spirit, purpose, and intent of the regulation. And the regulation is that if it's 10,000 feet or 10,000, remember that number, 10,000 feet or below, that you could do such and such. If it's 10,000 or above, you have to do this. And I appreciate that, but I want to, doesn't meet the variance. So, I'm very concerned about that. As Mr. Shea pointed out, developers and city worked very hard to come up with this number. And every time we consider, oh, well, maybe we'll just give them a foot here or a foot there, and before you know it, we're given 5 feet and 10 feet. So those are my concerns. Anybody else have a comment?
I agree with what you said. Again, like we heard, there's the administrative adjustment option, but that criteria is different from ours. And so I think the standard that we have to meet is pretty clear with this lot type versus that lot type.
Okay, anybody else? Ms. Sun, you have a comment?
I appreciate the plea from the applicant, but the 4 factors are not met. So I'm not in favor of the variance.
Okay, Mr. Shea.
I am not in favor.
All right, do I hear a motion to uphold the zoning administrators? What are the wording I need to use? I know uphold is right.
I would make,
How about just deny the variance?
Make
a motion to deny the variance.
Okay, we're upholding the denial. Okay, that sounds good. All right, Mr. Williamson made,
I seconded.
all right. Mr. Shea seconds. Do I hear, let's see, Mr. Davis? You vote yes to uphold the denial.
Yes.
Ms. Sun,
Son, yes.
Mr. Williamson,
Yes.
Mr. Shea,
Sure, yes.
Dryden, yes. So the appeal is denied and we uphold the
Variance.
The variance.
variance. Oh, I'm sorry, it's late.
Late.
The variance
Sugar low.
is denied and we uphold the administrative decision. Thank you very much. Okay, now finding of facts and conclusions of law. Right, I hear a motion to approve those as written.
Motion to approve.
Thank you, Mr. Shea. Do I hear a second?
1 second.
Ms. Sun, second. Mr. Davis?
Davis, yes.
Ms. Sun?
Son, yes.
Mr. Shea?
Yes, sure, yes.
Mr. Williamson?
Williamson, yes.
Dryden, yes. So we approve the finding of facts and conclusion of law as written. Thank you all very much. Okay, I have a question. It is now 1 o'clock. So do we have lunch or do we not have lunch or? All right, shall we do a working lunch or eat fast? What is your recommendation, board?
Yeah, we have three cases left and they're all recommendations. They're all recommendations. We can try to get through them fairly quickly, but if you guys want to grab your doing and get started.
Board, what would you like to do?
Yeah, that's okay.
We can do that?
That's not rude?
Yeah.
I think it's rude.
Well, you don't have to eat.
You don't mind.
You don't mind. You want to keep going? All right, I'm hearing staff loud and clear. Let's take 10 minutes.
Okay, all right, we're going to adjourn for 10 minutes and resume. Thank you very much.
Applicant for
Thank you. And it's a go.
This is case number variance 2025-00008. Andrew D. Spalding for property located at 721 East Sugar Creek Road, owned by Light Rail Properties LLC. It's a two variance request. The first variance is to Article 4.3, Table 4-1, to eliminate the corner side setback of 10 feet to 0 feet along Sugar Creek Road right-of-way. The second variance is to Article 4.3, Table 4-1, to reduce the side setback of 5 feet to 3 feet along the eastern property line. This is Exhibit 1 showing the vicinity map, and it's off of East Sugar Creek Road, south of 29. The zoning in Exhibit 2 is N1C zoning, Neighborhood 1 zoning districts. In Exhibit 3, you'll see an aerial map. Here in this pink dotted line is the railroad right-of-way. It's 100 feet right-of-way. Exhibit 4 shows a street view of the property. The variance is, there's two variances. The first one to eliminate the corner side setback of 10 feet to 0 feet along Sugar Creek Road right-of-way. And the second variance is to reduce the side setback of 5 feet to 3 feet along the eastern property line. Here is in Exhibit 6, the survey with the proposed building envelope. Here is the railroad right-of-way. The NCDOT encroaches into the property by about 10 feet. And then this is the existing buildable area at 744 square feet. Without the variance, with the variance, it would be 1,148 square feet. This in Exhibit 7, this is the recorded plat. Here is the property. And just the survey. Here is the NCDOT encroachment onto the property. And then the railroad right-of-way is here. And that's the building envelope.
Wow.
In Exhibit 9, you can see the Mecklenburg County time machine on March 29, 2015. This is the site without the overhang, the overpass.
So, Crystal, based on that, can you use your pointer and show me how big the property is?
Sure, it's from here.
Okay, thank you.
And then Mecklenburg County Time Machine Exhibit 10 shows in November 15th of 2017, the overpass started being constructed. This is the lot.
Wow.
In June of 2014, this is the Google Street View prior to the construction. And then April 2017, here is the lot with the construction. And this is a good time to go over your findings and facts.
I'd say it was peculiar to the property for sure. Okay, you can continue. Thank you.
Thank you. Unnecessary hardships would result from the strict application of ordinance because the required setbacks in combination with the railroad right-of-way and the NCDOT encroachment, which reduce the lot size, creates a small 744 square foot buildable area. The western property line requires a 10-foot corner side setback because it abuts a street right-of-way. However, East Sugar Creek Road is an overpass and the parcel has no access to East Sugar Creek Road. The hardship does result from conditions that are peculiar to the property because there is a 100-foot deep railroad right-of-way that crosses the rear of the property. The construction of the East Sugar Creek Road overpass reduced the lot width. The hardship does not result from actions taken by the applicant, as they did not create the lot or the railroad or overpass for the East Sugar Creek Road. The requested variance is consistent with the spirit, purpose, and intent of the ordinance in that the public safety is secured and substantial justice is achieved. The variance would make development of the vacant parcel feasible. Granting the variance will not adversely affect the adjacent properties. The 2-foot reduction of the side setback abutting the adjacent single-family home is equivalent to what could be achieved with an administrative adjustment. The reduction of the corner side setback to 0 feet would not create safety concerns for the East Sugar Creek overpass because the NCDOT encroachment in stormwater drainage facilities is 10 feet wide and limits the ability to build against the bridge. Granting the variance would not alter the essential character of the neighborhood. And here is the sign posted on the property.
Any questions for staff? Was this a recently purchased lot? Do you know? I mean, I'm just curious. Okay, thank you. Any other questions for staff? Is there anyone here for or against to speak? Would you like to speak?
I'd like to, if you have any questions, but.
Well, if you're gonna do that, you need to step up there and let me swear you in. It's on a recommendation, so he doesn't have to. Okay, so you're fine then.
Okay.
All right. I appreciate it. Sorry about that. No, you don't have to say anything. It's all right.
Okay.
Because it's on the recommended agenda.
The applicant shared a PDF document, so I was just gonna scroll through it for him.
A PDF document. We'll look at the little lot size.
That shows the lot lines. It's a little faint, but that shows how the lot lines are now.
If you're gonna speak.
Yeah, you gotta-
Sworn, they can only accept sworn
Right.
testimony, so you need to take
I can't, I'm sorry, I can't help myself. So.
Okay, we'll move from the,
Remove it from the recommendation agenda? I don't think.
I'm gonna recommend that you don't speak. so-
yes, we're gonna recommend you don't speak. Just FYI. It's okay. We got it. Okay. Yeah, that's what I wanted to see, that one. So. Thank you. All right, let's go into deliberation. Anybody with comment or?
I make a motion to approve.
Second.
Mr. Shea makes a motion to approve. Mr. Williamson is a second. Mr. Davis,
Davis, yes.
Ms. Sun,
Yes.
Shay, yes.
Williamson,
Yes.
Dryden, yes. So the
Make a motion to approve the finding of facts. Edited.
okay, Mr. Shea, do I hear a second?
Davis.
Thank you, Mr. Davis. Mr. Williamson,
Williamson, yes.
Mr. Shea,
Shay, yes.
Ms. Sun,
Yes.
Mr. Davis,
Yes.
Dryden, yes. So, the variance has been approved. And the finding of facts and conclusions of law as written have been approved. All right. Moving on. This is variance number 2025-00014 for the property located at 1500 Shamrock Drive. Okay,
This is case number 2025-00014 to reduce the rear setback. 10th Gate LLC, represented by David Murray, for property located at 1500 Shamrock Drive, owned by 10th Gate LLC. The variance request is to Article 4.3 from setbacks for N1C zoning. In Article 4.3, Table 4-2 of the UDO, to reduce the corner side setback from the required 10 feet to 5 feet, a 5-foot reduction, and to reduce the rear setback from required 30 feet to 18 feet, a 12-foot reduction.
That was the correction on the agenda as well. The agenda that you have, says 30 feet to 12 feet, foot reduction. It's backwards.
what was backwards?
Sorry, 12 and 18 is backwards, so it should be a reduction of 30 feet to 18 feet at 12 foot.
Finding of facts are
Oh.
correct.
Findings of fact are correct.
Okay, all right, go ahead.
Here is an Exhibit 1, the vicinity map. Close to Downs Avenue and Florida Avenue. South of 29. The zoning is N1C, Neighborhood 1 zoning district. Here is a close-up of the aerial map of the property and Exhibit 3. This is a street view of the property, of the building. There's an existing commercial building there. The variance request is to reduce the corner side setback from the required 10 feet to 5 feet, a 5-foot reduction, and to reduce the rear setback from the required 30 feet to 18 feet, a 12-foot reduction. The applicant agrees to the condition of owning a single-family detached dwelling and associated accessory uses and structures be permitted. This is a survey of the lot on Exhibit 6. So here is what is existing, 950 square feet is the building envelope. Without the variance, with the variance is 1,500 square feet. That's the proposed 5-foot corner side setback and the proposed that 18 rear yard setback. What's existing is to be demolished. The vacant commercial building is to be demolished.
And what surrounds it are all single family, is it livable, I mean, are those all single family homes?
Let me just quickly look at something. Yes, the answer is yes.
Okay, thank you.
Here's the plat in Exhibit 7 showing that it's legal non-conforming. And this is the lot right here. This is the lot right here. If you can take a few moments to go over your findings of facts.
Okay, thank you. You may continue.
The necessary hardships result from the strict application of the ordinance because of the small size of the lot. Without the variance, the buildable envelope is small and impacts the ability of the site to be developed for new home construction. The hardship results from conditions that are peculiar to the property because of the small size of the building envelope and lack of depth and width of the property, which creates a small building envelope. The hardship does not result from the actions taken by the applicant. The lot is legal non-conforming and does not meet the minimum lot width and area for N1C zoning districts and was not created by the property owner. The requested variance is consistent with the spirit, purpose, and intent of the ordinance in that the public safety is secured and substantial justice is achieved. The requested variance will permit for a home to be built and the elimination of the abandoned commercial building, which was non-conforming use for the zoning of that area. Granting the variance would not alter the essential character of the neighborhood. The applicant agrees to the condition of owning a single family detached dwelling and associated accessory structure uses and structures be permitted. And here's the sign, exhibit 11 shows the sign on the property. Do you have any questions?
Any questions for staff?
It's a good thing for the neighborhood.
I think so, yeah. Get rid of the ben, I mean, go back a slide. Yeah, I don't, how, it's a commercial building, how would you even? Whenever it was built, there was no parking, how would you even get into the building? Unless you parked on the street, I guess. So, okay. I think it would be good for the neighborhood. I mean, everything around it is single family. I think it would be a good thing to get rid of that. Because it looks like it's abandoned, right? The building is abandoned.
Yes.
All right, we will move into deliberations.
I make a motion to approve.
Thank you, Mr. Shea. Do I hear a second?
Second.
Ms. Sun, thank you. Mr. Williamson,
Williamson, yes.
Mr. Shea,
Say yes.
Ms. Sun,
Yes.
Mr. Davis,
Yes.
Dryden, yes. So the variance is approved. Do I hear a motion to approve the finding of facts and conclusions of law as written?
I'd like to make a change to 16.
Okay,
Just can't stand it.
okay, what?
I'm gonna say the requested variance will eliminate the non-conforming abandoned commercial building and allow a single-family home to be built.
All right, say it one more time.
Oh, write it down. The requested variance will eliminate the non-conforming abandoned commercial building and allow a single-family home to be built. Sanchez Myers, okay with that? Just a little clearer. I almost want to say 17.
Granting the variance will not alter the essential character of the neighborhood.
It actually will help the character. I guess we don't have to go there.
Yeah.
Okay. So I'd make a motion to approve the finding of facts with
As amended,
as amended. Thank you.
okay? Do I hear a second?
Second.
Thank you, Mr. Davis. Mr. Williamson,
Williamson, yes.
Mr. Shea,
Say yes.
Ms. Sun,
Yes.
Mr. Davis,
Yes.
Dryden, yes. So we have approved the finding of facts and conclusions of law as amended. And I hope somebody wrote that down because I only got as far as eliminate. So when I read the minutes next time, well, it'll be correct. Okay, thank you very much. All right, one more. Variance 2025-00015 for the property located at 927 East Boulevard.
All right. This is by, for Catherine McDonald, represented by Tim Finan, for property at 927 East Boulevard, owned by AOCC Joint Ventures LLC. It's two variance requests to renovate an existing office building. It's a renovation and an expansion of an existing office building. And the variances are to Article 10.3B, Table 10-1, Line B, requesting to increase the frontage build to zone, or the BTZ, from the frontage setback line to usually is 0 to 20 feet. We're requesting 0 to 25 feet, a 5-foot increase along the East Boulevard frontage, and a variance from Article 10.3-D, Table 10-3, Line A, to reduce the minimum building length as a percentage of the lot width from the required 60% down to 40%, which is a reduction of 45.3 feet. This is a vicinity map of the property. We're at the corner of East Boulevard and Dilworth Road West, near Park Road. This is existing zoning map on Exhibit 2. It's existing zoning of neighborhood center zoning district, and you can see the footprint of the existing building. Exhibit 3 is an aerial map showing the existing office building and parking that supports that building. And Exhibit 4 is street view, again showing the existing office building, its relationship to East Boulevard to the left of the page here. And then the bottom street view image is from East Boulevard looking towards the building. So this is kind of the area, the side that we'll be talking about for the percentage of lot, building length to lot width. And then this area here is where the build to zone would be.
So John, that top one, so you're standing on Dilworth Road then?
Correct. Yeah, this is Dilworth Road curb line here, looking towards north towards the building.
Okay.
Exhibit 5 is the variance request. Again, 2 variance requests. One is to the build to zone to change that distance that the building would be from the street from 0 to 20 feet to 0 to 25 feet. It's basically just a 5-foot increase, allowing the building to be 5 feet further back along East Boulevard frontage than what the ordinance required. And then a variance to Article 10, Table 10-3, Line A, reducing the minimum building length as a requirement of the percentage of the lot width. Ordinance requires 60% of the lot width to have building frontage, and the request is to reduce that down to 40%. So to allow 45.3 feet reduction of the required building length. And I'll show that on the site plan here. This is Exhibit 6 is the existing conditions site plan showing the existing building's footprint here. It's kind of like an U shape. Existing parking and drive aisle here. This blue line indicates the proposed build to zone, 25 feet, and then the black line is the required 20-foot build to zone. And there's just again a 5-foot difference in those distances. Exhibit 7 is the site plan, and this illustrates the minimum building area that would need to be constructed in addition to their addition that they're doing in order to meet the ordinance requirements. So these little squares here indicate the existing footprint. And so they're doing an addition off to the side. It's roughly, I think that's roughly about 5 feet of an addition off to the side here. And then they're adding on to the front of the building. And so the majority of the front of the building will meet the 0 to 20-foot build to frontage requirement here, this front building line. This area here would not meet it, and that's due to how the curb of the street juts out as you approach the intersection. So this is the area that would not be in the required build to zone, and thus the request to increase that build to zone by 5 feet so that it's within that blue line distance. And then the distance of additional building that width that would have to be added in order to meet the ordinance requirement is 45.3 feet. And that would impact the location of the existing driveway, which they would be maintaining. Slide 8, Exhibit 8 is the variance criteria, and I'll give you a second to look at those. Let me know when you're ready to move on.
Did I read that they went through the Dilworth, it's called?
The HOA, not HOA.
Historical district.
Well, yes, I think they've already received a
Yeah.
COA from the historic.
Are they gonna paint the building?
I'm not sure what all's in the COA and what the district approved.
Okay, go ahead.
Unnecessary hardship would result from the strict application of the ordinance because the applicant is proposing a renovation in addition to the existing building, which would trigger compliance to the build to zone and minimum building length standards of the ordinance. Without the requested variance, the applicant would be required to build eastern portion of the building closer to the street to meet the build to zone standard, creating an inconsistent facade and build a building that's larger than is needed for the applicant. The larger building would require changes to the existing driveway on East Boulevard and the removal of proposed parking. And the existing building is 89 feet wide. Applicant is adding approximately 12 feet to the width of the building. Hardship results from conditions that are peculiar to the property because the property is because there's different words there, because the parcel is 245 feet wide and would require a 147-foot wide building. Additionally, there's an existing driveway on East Boulevard that would have to be removed or relocated in order to accommodate a 147-foot wide building. Hardship does not result from conditions or actions that were taken by the applicant. It's because the hardship results from the ordinance requirements for the lot width and location of the existing driveway. And the requested variance is consistent with the spirit, purpose, and intent of the ordinance such that public safety and secured and substantial justice is achieved. The property is developed with an existing office building. The variance would allow that office building to be expanded. The existing building is approximately 27 feet back from the required build to zone, and the building is 89 feet wide. The proposed addition would bring the development site incrementally towards compliance with the UDO by locating the building's facade 25 feet from the build to zone, and which is five feet more than the required. The addition increases the building's width by 12 feet, bringing it from 89 feet to 101.7 feet. Granting the variance would not impact the adjacent properties. The requested variances are related to the building's relationship to East Boulevard street frontage.
Can you go back and show me where the built that right there? So they want to keep the entrance and they're going to keep most of that parking lot.
Yeah, the parking lot gets reconfigured slightly compared to so that's what it looks like today. It's just a single double loaded row. And then they would expand that parking lot a bit. But if they were to meet the strict requirements of the ordinance, they would have to relocate this driveway and they would lose an entire bay of their proposed parking to meet those requirements.
So they're creating a more symmetrical building opposed to what it was.
Yeah, currently it's a U shape and basically making it a square.
Yeah, it was probably two separate lots in Dilworth when it was originally constructed, and they just expanded and did a parking lot on one lot and then the building on the other. So now they're gonna blend them together.
So now it's gonna look like this.
It won't look exactly like that, but
close.
Because that's from the UDO thing.
Yeah.
Yeah.
Okay. Okay. All right. Anything else, John?
No, just the last slide, exhibit 11 is the photo of the sign on the property. That's concludes my presentation.
So where the sign on the property is that where they're going to expand the building?
I think this is the East Boulevard frontage. It looks different, so I'm wondering if maybe some trees were.
They cut down all the trees, yeah.
Probably
Why do they do that?
Probably in prepreparation for the addition on the front.
I'm sure they were permitted.
I'm sure they got a permit.
They are adding the depth of the building is 60 feet. And it's gonna be 85 feet after the addition.
Okay.
So they're adding about 25 feet to the front of the building.
All right, any other questions for John? Okay. Any discussion? Do I hear a motion?
Make a motion to approve.
Thank you, Mr. Williamson. Do I hear a second?
Second.
Thank you, Mr. Davis. Mr. Williamson,
Yes.
Mr. Shea,
Say yes.
Ms. Sun,
Yes.
Mr. Davis,
Yes.
Dryden, yes. So the variance is approved. Do I hear a motion to approve the finding of facts and conclusions of law as written?
I think there might be a typo if it's
Okay.
based on what we saw on the slides. Let me find it. You're familiar with the property. I think it's fine in the findings. It's just messed up on the PowerPoint. Number 11 looks okay.
Hardship result from conditions that are peculiar to the property because the property, oh, you got because in there twice. Are peculiar to the property because the parcel.
Oh, yeah, you're right. There's.
So it's peculiar to the property because the parcel is,
Yes.
Take out because the property.
yeah, they've got it. Parcel is 245 feet wide and would require 175. Okay, so just take out property because they just
3 words.
3 words. All right. Now do I hear a motion as amended? Finding of facts and conclusions of law.
Motion to approve minutes as amended.
Thank you, Mr. Shea. Do I
Sorry,
hear?
my apologies. Motion to approve finding of facts as amended.
Okay, finding facts and conclusions of law. Okay, good. All right, Mr. Shea, thank you. Do I hear a second?
Sun second.
Ms. Sun? All right. Mr. Williamson,
Williamson, yes.
Mr. Shea,
Say yes.
Ms. Sun,
Yes.
Mr. Davis?
Yes.
Dryden, yes. So the finding of facts and conclusions of law are approved as amended. All right, we need to do one other thing. We have to look at the minutes from last month's meeting. And I need to look them over. I didn't see anything that just jumped out at me that was incorrect. Do I hear a motion to approve?
Motion to approve the minutes.
Thank you, Mr. Shea. Do I hear a second?
Sun second.
Thank you, Ms. Sun. Mr. Williamson,
Williamson, yes.
Mr. Shea,
Say yes.
Ms. Sun,
Sun, yes.
Mr. Davis,
Yes.
Dryden, yes. So the minutes are approved. This meeting is now adjourned.
And it is 1:43 PM.
All right, Crystal.